Welcome to the January 28th, 2025 Zoning Board of Appeals meeting of the Town of Raymond. The Zoning Board of Appeals will come to order. This board does have a quorum. I am now going to do a roll call. David Murch.
Greg Dean.
Fred Miller.
Pete Lockwood.
This is a public proceeding, and unless the board specifically votes to go into executive session, you have the right to hear everything that is being said and to look at all of the exhibits that are presented. Please notify the chair if you're unable to see or to hear. The board works from a published agenda and will be considering tonight's items in the following order. Call to order, minutes, old business, new business, Todd Roma for a administrative appeal of notice of violation, then code enforcement, communications, and finally adjournment. In each instance, the burden is upon the applicant to demonstrate compliance with the provisions of the applicable ordinances or state law. After the board votes on the merits of each application, it will prepare a written notice of decision. Because the notice of decision may substantially affect any appeals rights, and also as a matter of courtesy, the board asks those attending the meeting with regards to a specific application not leave until the board has completed its discussion. Generally speaking, appeals from adverse decisions must be filed with the Superior Court as otherwise provided by law within 45 days of this board's decision. Also, to be certain that you preserve your individual rights to file any such appeal, you must be certain that the board's record evidences your appearance this evening in opposition and the basis for your opposition. All persons speaking, including the representatives of the applicant and members of the public, are asked to stand at the microphone and to sign the speaker sheet, state their names, their address, and affiliation with the application, either being for, opposed, or neutral. All persons speaking shall address all remarks or questions to the chair. This meeting is not over until the board has formally adjourned. Any discussion not included on the meeting agenda or accepted by the board is to be held until adjournment or conducted outside the meeting room. Sandy, in our agenda, it says we don't have minutes, but we do. So, right?
Did I send you minutes?
You did.
Oh, well, hell, I missed that on the agenda then.
Okay. Because I got them and I read them.
That was what date, David?
Tuesday, September 24, 2024. Draft minutes.
Okay, that's probably why I missed it, because I was like, oh yeah, no, we didn't meet last month. Okay, yeah, if we want to go with that would be great.
Okay. Greg, Fred, Pete, did you all have opportunity to review these? Yeah, okay. I'm going to make a motion to accept the minutes as drafted. Do I have a second?
I'll second the motion.
Do we have any discussion in regards to that? So Pete, we have to do like a roll call vote tonight since you're virtual on this. So all those in favor of accepting the draft minutes? David Murch, yes.
Greg Dean, yes.
Fred Miller, yes.
Pete Lockwood, yes.
Okay, thank you, sir. Old business, we have none tonight. Next up is new business, applicant Todd Roma, location 141 Raymond Hill Road, map 13, lot 29, zone RR. Description, administrative appeal of notice of violation dated August 29, 2024 for holding weddings and public events on the premises. Sandy, I believe that public should have been private, is that correct? If you're speaking, Sandy, I think I can't hear. There we go.
I believe that there was a public one as well. Chris or Jason can answer that better.
Okay. Well, let's put it this way. Administrative appeal of notice of violation dated August 29, 2024 for holding weddings on the premises. Does that meet with your expectations? Yeah. Okay. So tonight, obviously, we have a lot of people. We have a lot of representation for the zoning board. We do have an attorney that will be assisting us. That's Attorney Hamer. You'll see me looking over there to reference him. from time to time. Tonight, also, I believe Mr. Roma has Attorney Skolnick helping to represent him. Is that, I have your name correct?
Yes.
Very good. And on the code enforcement side of things, we have the Assistant CEO, Jason Williamson. We have our CEO, Chris Hansen, as well as Attorney Grady Burns helping to represent code enforcement, correct?
That is correct.
Okay. Just sort of to give you an idea of tonight, and Mr. Hamer, you can help me with this to make sure I'm not steering people wrong, but we will go through a quick overview of this appeal, make sure it meets the conditions for which we can review it. Then we'll give opportunity after we get through our initial part of this for our appellant and his representation to speak. The board will then take some time to ask questions of the appellant and his representation. Then we will take opportunity to listen to code enforcement and their representation, present their side of things. The board will take time to ask questions at that point as well. Then we'll sort of have some back and forth. I don't want to call it back and forth with yourselves, but you'll each have had an opportunity to hear each other and then have some responses to those presentations. Does that match expectations? Does that sound okay, Attorney Hamer?
That sounds like a good plan.
Very good. So tonight we have an appeal from Todd Roma. One of our considerations is the timeliness of this appeal. It is timely. It was issued on the notice of violation was issued on October 29th, 2024. Appeals must be filed within 30 days. 30 days would have given us a November 28, 2024 date, but that is Thanksgiving, and the office was closed until December 3rd, so the soonest this appeal could have been received by the town would have been December 3rd, or I should say the last day that it could have been received, and that is the date that it was received. So this appeal is timely. Standing, the appellant is the recipient of the notice of violation, so there is standing. A complete application has been submitted. All fees have been submitted. This board does have jurisdiction under Land Use Ordinance Article 6, Section 6.2.A.1. The Board of Appeals shall have the following authority, subject to the provisions of this chapter, to hear and decide appeals on a de novo basis from orders, decisions, determinations, or interpretations made by the code enforcement officer or the building inspector. And then finally, conflict of interest. Board, do we have any conflict of interest that need to be brought forward?
I think Tom is on.
What's that?
Tom is up.
Oh, good. Tom, can you hear me all right?
Yes, I can. Thank you.
Okay. Tom, why don't you just announce yourself to the people here?
Tom Hennessy.
Yeah. Tom is our fifth and member of our Board of Appeals, so he will be joining us tonight for this. Again, do we have any conflicts of interest?
I don't, that I know of.
Okay. So we are good to go with regards to reviewing this appeal. A site walk was done regarding this appeal. This was conducted on Saturday, January 18th of 2025. Greg Dean has the report for that, I hope.
I don't have a copy of it. I sent it to Sandy.
Is that it?
Yeah, that's it. Would you like me to?
Yeah, if you want to read that into the record.
Okay. So the site walk was at 141 Raymond Hill Road, January 18th, 2025, started at 9 a.m. Attendance is as follows. From the ZBA, David Murch, Greg Dean, Pete Lockwood, Fred Miller were present. Tom Hennessy was absent. The Assistant CEO, Jason Williamson, was present, and the applicant, Todd Roma, was present. The summary of events is as follows. The site walk commenced promptly at 9 a.m., led by David Murch. The attending members observed the applicant's property at 141 Raymond Hill Road. The site walk concluded at 9:05 a.m., as noted by David Murch.
Okay. I'll make a motion to accept that site walk report into the record. Do I have a second?
Second.
Second.
Okay, any further discussion? All those in favor, David Murch, yes.
Greg Dean, yes.
Fred Miller, yes.
Pete Lockwood, yes.
Tom Hennessy, yes.
Very good. For documentation that's been provided to date, we have the appeal with documentation from Todd Roma, as well as follow-up documentation from his legal representation, Michael J. Skolnick. We also have documentation from Chris Hansen, Exhibits A through H. We also have the 2019 appeal that was submitted by Todd Roma and Jessica Dobson with regards to a conditional use permit for the property. And we also have a memo to Wayne Jones from Catherine Plummer regarding the status of his memo from, or reporting from 2019. And I also have, which I will read into the record, a definition of short-term rental, which was provided by Attorney Hamer. For purposes of the municipal role in statewide housing production goals, the term short-term rental means living quarters offered for rental through a transient rental platform. 30-A MRSA Section 4364-C2. The definition of a transient rental platform is an electronic or other system, including an internet-based system that allows the owner or occupant of a living quarters in this state to offer the living quarters for rental, and that provides a mechanism by which a person may arrange for the rental of the living quarters in exchange for payment to either the owner or occupant, to the operator of the system, or to another person on behalf of the owner, occupant, or operator. 36 MRSA, Section 1752, 20-C. Thank you, Mr. Hamer, for providing that to us. Tonight's appeal, we as a board get to consider that on a de novo basis. Mr. Hamer, can you just confirm for everyone what de novo means and how we are to interpret that?
So a de novo hearing means that you have the ability to take evidence and to make a decision based on the record, and you're not conducting an appellate review. So you have the authority to rescind the NOV, modify it, or affirm it.
Okay, very good. Thank you. Also, another question that I had for you, if we were looking at our shoreland zoning provisions, it specifically states that with regards to an appeal like this, that the burden of proof is on the appellant. In our land use ordinances, it doesn't specifically state that. Can you let us know as a board what level of proof do we need tonight? Or
The
should be
burden
looking?
of proof is always on the appellant.
Yep.
So in this case, it would be the Romas and their attorney. And the standard of proof is, it's more likely than not standard.
Okay, very good. Thank you. And I've had forgot to mention beforehand that this is a public hearing, obviously. Once the parties have had a chance to give their presentations, the board has had a chance to ask them questions. We will open it up to public comment. If the people are here in support of this appeal would give an opportunity to speak first. Then I'll ask anybody who is opposed to this appeal to come up and have an opportunity to speak as well. And then anybody who is neutral to this appeal would have an opportunity to then come up and speak. And that would be through the public comment, which we'll have later. So, all right, everybody good to go? All right, so Mr. Skolnick.
Thank you, Mr. Chair, and members of the board. I do have one handout that I want to give out to you. I just gave one to council as well.
Thank you.
And I do apologize to the members of the board who are joining us via Zoom. I can explain anything that we use in this packet. First off, my name is Michael Skolnick. I'm an attorney for Todd Roma as well as Jessica Dobson. They're the owners of 141 Raymond Hill Road and also the Roma Farm LLC. We're here tonight specifically to address and appeal the 2024 notice of violation and ask this board to rescind that notice of violation. First off, it incorrectly determines that Todd and Jessica are unlawfully using their property to host private events, i.e. wedding venues is specifically mentioned in there. This notice of violation actually specifically calls out our client's conduct, which is ostensibly the same conduct as many other properties are using in this town. However, it does single out this property specifically. We're going to ask this board to find three things. First, there's no prohibition on rental properties in the town of Raymond. There's nothing in the ordinances, there's nothing anywhere else that says you can't rent your property. Two, the primary use of this property is a single-family home. It's a residence, and that's what it is on a year-round basis. And the third is that a rental of the property is a lawful accessory use within the rural residential district. I do want to provide some background about this property before we begin on our ordinance interpretation and some of the conduct issues from the town as well. Back in 2002 is when Jessica and Todd purchased this property. It wasn't originally purchased in the Roma Farms LLC. It was transferred in only a few years ago when they decided to really kickstart their business. It existed when they purchased it with just a residential dwelling. It also had a 1,400 and change square foot barn on the property. Since the 1800s, it was a farm property. A lot of residential homes also had barns associated with them, especially in farming areas and agricultural areas. They decided over the next 6 years to renovate the property and renovate the barn specifically. They did the house and then they moved over to the barn. Like so many other people in the town of Raymond, they saw an opportunity with this property to do some sort of rental, have some sort of secondary income. That's not an isolated situation for this town, and it's one of the main economic drivers of this community as well. Since 2007 and after the renovations, Todd and Jessica began using their barn to host the odd event here and there. Weddings, baby showers, Halloween parties, things like that. They were all private events. The public has never been invited to these events. It's not open, it's not a quasi-public use, and it's not a public use. It's been nearly 18 years now since they own the property, and they've been, just like everyone else does at their property, hosting certain events. First and foremost, this is a residential property. It is a place that their family uses on a year-round basis as their primary home. A far distant second, it's a seasonal rental to host some events as well as to rent out the home. In 2019, they wanted a little bit more clarification on what the ordinance says, which is pretty much the reason we're here tonight as well. What they did is they went to the town. They went to Jim Seymour, who's the planner, and they went to, at the time, Scott Dvorak, who was the CEO. They said, are we allowed to host weddings at our property? CEO Dvorak at that time, he said, there's nothing in the ordinance that says that you're not. There's no zoning violations were present here. The town does not regulate rental properties at all, and there's no prohibition on hosting functions no matter what size. They wanted something on the books. They asked the town what to do. With the town's recommendation, they submitted an application to this board for a conditional use permit. That conditional, why did they do that? It's because the ordinance doesn't address anything. There's literally no guidance on whether rental properties are allowed, wedding venues are allowed, or anything like that. So if they wanted to do it at their property, they wanted the town's approval to do that. They didn't have to, but they did. They wanted to go in front of this board for a conditional use. This board denied that application for a simple reason, and we don't deny that that reason was correct. Conditional use, wedding venues are not a conditional use in the rural residential district. You shouldn't have approved that conditional use permit, and you didn't. But that's the limitation of why you denied it. It's because it's not a conditional use. We look at the rural residential district itself. Actually, let me back up for 1 second. I typically like to do these things where I speak about the ordinance, and then I speak about the conduct. I know there's a lot of people who want to speak tonight, so I would ask the board how you want me to proceed, whether we want to talk about just the ordinance and the law itself, and then I can go into specific conduct of the town later after you have the opportunity to converse with me a bit. Is that okay?
I'm going to leave it to you as to how you'd like to
All right.
presentation.
All right, as long as I have some time to get into that if we have to move past it. Looking at the rural residential district, specifically the notice of violation says wedding venues are not a conditional use, they're not a permitted use, therefore they're prohibited, they're not allowed. Looking at the entirety of the ordinance, no matter what district you're in, wedding venues, private event spaces, function halls, ballrooms, private rentals, anything of the sort, it's not allowed in any district in this town if that's the way we're going to interpret it. Doesn't matter if you're a residential area, doesn't matter if you're an industrial area, doesn't matter if you're a commercial area. Nobody in Raymond, according to the CEO's determination, can host a wedding at their property. Can't rent your property out. If we take that one step further, there's no rentals in the town at all. That's what it specifically doesn't allow it in the ordinance, so therefore you're not allowed to have it as a use. That's what the blind interpretation from the code enforcement officer is saying here. It leads to an illogical result. Let's look at the logical result instead. What are the allowed uses in this zone? Single-family residences, accessory structures, and accessory uses. Both are permitted uses. I want to point to the definition of accessory use under your ordinance. It's a use which is incidental or subordinate to the principal use. Accessory structure. An a structure of a nature customarily incidental or subordinate to that of the principal structure or the primary use to which the premises is devoted. We need to ask a few questions when we're talking about accessory. First, what's the main use of the property? I don't think there's any doubt here that the main use of this property is a single-family residence. Jessica, Todd, their 2 kids live there throughout the year. 12 months out of the year, 365 days. That's the clear principal use of this property. The home and the barn are rented out on a seasonal basis from July to the beginning of October, I believe. And that's on a periodic. There hasn't been a single year where that's every single weekend. That's clearly an accessory use. Accessory uses are allowed in this district. You're allowed to use it for venues, as a venue. You're allowed to host parties in it. You're allowed to rent out your property. And well, that's in accordance with how the town of Raymond has always historically acted. You're allowed to rent your properties. Let's go to the structure itself. What is the primary use as a building? They live in their home. That's the primary structure. The barn, where any of these parties that they host or any of their residential rental tenants use, is the accessory structure to the property. It's clear that the primary use is the residential home, is them living in their home, and the primary structure is the home that they live in. The barn is an accessory use. The use of the barn to host events is an accessory use. Accessory uses are specifically allowed in this zone. We can try and shoehorn this into wedding venues that doesn't even have any place in the ordinance itself throughout the entire town, or we can logically look at this and just simply state, oh, it's an accessory use. They're allowed to do that. Let's act like the town has acted for its history and allow rental properties, and look, their accessory use of their barn, that's allowed. When they went to meet with their town representatives, first back in 2017, I believe, they confirmed this. They looked at this. They said there's no violation. There's nothing in the ordinance that says they're not allowed to do it. We can't see anything that points you in the wrong direction. The first time they've heard of anything was after the 2019 denial of this board. It first brought it up that this might be an issue. Then a disgruntled neighbor wrote a letter in after that hearing and said they're still doing it. Look, they're still hosting weddings. However, like I said earlier, this board only decided that weddings are not a conditional use. Completely agree with you. However, they are a permitted accessory use. That same owner wrote another letter just before the 2024 notice of violation. Said, look, they're still hosting wedding events. Absolutely agree. Same reason. Still allowed to. There's also some issues here about just equal protection rights. I mean, specifically, the Equal Protection Clause demands a similarly situated persons receive similar treatment under the law. The principle of uniformity within zoning laws itself, it mandates that all regulations within a district are applied to each property within that district. That requirement itself is intended to ensure that all property owners within the same district are treated equally and that there is no improper discrimination or favoritism. I have a few examples. Within the town itself, just a brief internet search, weddings in Raymond. You can find Kingsley Pines Camp. My understanding, that's always been a camp in town. However, in recent years, they have a huge barn. They're hosting private events. They're hosting weddings. I provided in your package a printout of their website that says Kingsley Farms Weddings and dates to book them, services they provide. However, the town has never issued a notice of violation to these people. Right on Raymond Hill Road itself, there's a horse farm down the way, owned by Tim Davidson. It's just down the road. It hosted 4 weddings last year itself. Town never did anything about it. There's actually signs posted directly outside the town hall pointing you to the direction of that horse farm for the wedding, and the town never did anything about it. Still hasn't. No issues there. There's a picture of that sign in the papers that I gave you as well. These are just a few examples how the town has turned a blind eye to some property owners, and now we're singling out our clients. If the town intends on adopting the illogical interpretations that weddings and events can occur on this property because they're not conditional or permitted uses, they have to enforce that regulation to everyone in town. They cannot specifically call out these folks. The town may come back and say this is a commercial use. However, there are commercial uses on that road, right in that district itself. Additionally, the law courts actually addressed some of this, and they said the fact that the use may involve income in some fashion does not change a fundamentally residential use to a commercial enterprise. They actually reasoned why they said that too. They said to rule otherwise would create an affirmative rule that any property rented for use by someone other than the owner is a commercial enterprise. So anytime anyone rents their property, it's going to be considered commercial, and therefore zoning violations occur. That's just an illogical result, and that's why the law court itself has said that renting your property doesn't automatically make it commercial use. This is a secondary use of the property. Primary purpose, as I said, is a residential use. That property is rented out from time to time. The Roma Farm, no, they don't specifically limit the use of the property for the people who rent it out. They rent out the home and they rent out the barn, they rent out the fields. They are allowed to use it for that time they rent it as they are the property owner. Just like you and me, I can have a wedding at my house. I can have a function at my house. I can have a work event at my house. There's nothing in the ordinance that prohibits it. There's nothing in most ordinances, I think, that prohibit it. Many properties in Raymond themselves, they advertise on Airbnb, Vrbo, whatever site you use. They advertise for large parties or retreats, or simply they just don't limit what you can do at the property. That's the same thing that's happening here. Yes, they say that you can host a party here. It's big enough property, why not? There's nothing else that says you can't do it. Again, saying that there's no rental is just an illogical result, and it actually kills the town's primary economic driver for this area, if that was going to be the interpretation. The law court also recognizes equitable estoppel as a zoning defense. Equitable estoppel pretty much says that if the town signs off on something and our clients relied on it, then they're allowed to continue doing that. In the past, Raymond officials since about 2007, nearly 2 decades, have known about the use of the property. There's been bridal showers, weddings, birthday parties, family parties, Halloween parties, all of these things. They've known about them. It wasn't until, prior to the 2019 ZBA hearing, they met with the town. They confirmed that they don't see any zoning violations. That was the planner and the acting CEO at the time. Then this board in 2007, they said you can't host weddings as a commercial use. We agree with that. We're not arguing it. And our clients, since that date, since the time they purchased their property, they specifically relied on the conduct of this town, of its code enforcement officer, of its planner. They relied on it. They paid for many renovations on their property so they can rent it out and host parties, so they can make it livable for themselves. This is an old farmhouse, an old barn. Now they have a very nice old farmhouse and a nice old barn. In Reliance, they probably wouldn't have purchased this property if they didn't think they were allowed to do this. The last thing I want to touch on is some of the conduct from the person who issued the notice of violation itself, and that's CEO Hansen. The law court regularly recognizes conflicts of interest from town officials and when they issue notice of violations. Typically, the town official reveals the fact that they have a conflict of some kind. There was nothing in the notice of violation that said that CEO Hansen had any communications with the one person here that actually is seeking to terminate short-term rentals or put requirements on short-term rentals. There's a neighbor just next door who is actively trying and through the Raymond Short-Term Rental Initiative seeking to impose regulations on short-term rentals, recognizing that there is none right now. From my understanding of communications between this code enforcement officer and that neighbor is they've been working together hand in hand to draft that proposed ordinance. Second, I do want to bring some attention back to that horse farm that we talked about earlier that had 4 weddings there. My understanding, and I didn't have an opportunity to confirm this on my own, but the CEO is actually a distant relative of the person that owns that farm, and there hasn't been any violations issued on them. This is just another example of not enforcing the same zoning violations on those people. There's conflicts here. A notice of violation issued by someone with conflicts should be null and void. Let the select board deal with this issue. If the select board finds that there's an issue, push it to them, and they can decide whether to issue another notice of violation. They're actually the board that decides whether to issue fines as well. So it might be proper to have them do so here. I do want to give an opportunity for everyone else to speak, and there are some exhibits that were submitted by the Code Enforcement Office that I have some responses to if I have an opportunity to do that later, but I think I've spoken enough for now and just want to answer any questions that you might have.
Thank you. I do have a few questions, and I'm sure the board does as well.
When you have a moment, I have a couple of comments as well.
Oh, please, Attorney Hamer. I have a moment.
Oh, now?
Sure, go for it.
Okay, great. I just want to make sure that it's clear what the scope of the board's authority is. There are a couple of arguments that were put forth, which really are arguments for report. The board doesn't have within its jurisdiction the ability to consider equal protection allegations of violations and equitable estoppel. Those are things that a court could imply, but that's not within your authority to consider. The question of conflict of interest for the NOV, that's arguably within your jurisdiction if you find that there is a clear and proper basis for the CEO's conduct. But I would suggest that the amount of proof required for showing a violation there would be a little bit higher than the standard, more likely than not. But just so it's clear, your scope of review is to applying or is making factual findings regarding the notice of violation within the context of the ordinances, and legal principles such as equal protection and equitable estoppel are just outside the scope of your review. So that's all I wanted to say.
I appreciate that. I actually did have that question for you with regards to the equitable estoppel, whether we did have the authority to review that. Just to confirm, with the appeal, Attorney Skolnick provided his documentation. Just to confirm, with you, there are 5 bullet points of discussion, or I should say 5 numbered points. The ones that you were just speaking to that relate to number 2, prohibition on private events implicates the appellant's constitutional rights, as well as number 4, the town is equitably estopped from requiring the appellants to cease using the barn for rental purposes.
All right, so just to go through the bullet points quickly.
Sure.
The question about constitutional rights in bullet point number 2, that's outside of something that's outside of the scope of your review. That's something that they can press on appeal if they feel necessary. Number 3 is fine. Number 4 is the equitable estoppel, so that is really outside the scope of your review.
And I would add that we do agree with that. We just would like to get it on the record for an appeal.
Yeah, that's fine. But I just wanted to make sure that the scope of authority is clear, because otherwise they could be spending a lot of time discussing things that they don't have the authority to do.
Very good. I appreciate that.
Okay, thank you.
Code enforcement, did you have anything to add with regards to those specific remarks?
Nope. We agree with your counsel, and it sounds like Attorney Skolnick, that the constitutional questions are outside of the scope of the review here, as well as the equitable estoppel question. There are questions for a court down the road if that's how it goes, but we will have some things to say on the conflict of interest piece.
Sure.
And as well as the discussion around the role of the select board, if any, in these enforcement matters. But I'm happy to defer those to our remarks.
That works for me. Attorney Skolnick, in the beginning of your presentation, you indicated you had 3 points you wanted to bring to us. No prohibition on rentals, mention of single-family home use and accessory use. How do those translate to the 5 initial points that were submitted with the appeal?
So they translate, the overall appeal itself here is that wedding venues of any kind, really, private venues, and I know there was discussion about whether it was public in the beginning, but there was never anything in the notice of violation that said we're using this property for public purposes. It is for private purposes. When you look at that, it's based on the interpretation that we're renting out the property for wedding events. Private wedding events, yes. However, I just want this board to recognize that there's no prohibition in the town about renting out your property.
Excuse me.
Maybe I didn't linearly say everything in order based on my letter, but those are the grand scheme and the points that I make. The second, 2 and 3, what you asked is the primary use of the property is a single-family residence, as well as hosting any parties within the barn itself is an accessory use. That goes to point number 1.
Okay.
Specifically, where I think this board should rely on and should fall within to rescind this notice of violation is, like I said, this is primarily a residential property that a family lives at. just because they own it in an LLC. Jessica is, by trade, she's an event coordinator. I would recommend that anybody purchase their property in an LLC, and I think most lawyers probably would, to protect them from liabilities, especially when you're renting out your property. That does not take it outside the scope of being just a rental property, their primary residence, just because it isn't an LLC. I think this third point goes to the fact that use of the barn is an accessory use. It's clearly an allowed use in the zone. If this board finds that hosting events in the barn, which are accessory structure and accessory use, that's an allowed use under the rural residential zone. And this appeal can stop right there.
So again, I did have a few questions beyond that. With regards to the 2019 appeal that came to the ZBA, did the property owners, did they appeal that to the Maine Superior Court?
They did not. They agree with the decision of this board that it's not a conditional or permitted use within the zone. Wedding venues specifically are not a conditional or permitted use in the zone. And that's what the question and the application to the board was.
At the end of that 2019 ZBA meeting, the ZBA did encourage the property owners to go to the town planning board to submit some proposed, on their end, try to work with the planning board to work towards having ordinances that would support the type of business that they were looking to conduct on the property. Did the property owners follow through with that action item?
No, they didn't. I mean, the reason to do that would be to change the ordinance itself, and there's a much longer process for that. I didn't look into that in this town. However, typically it's a select board, then to the planning board, back to the select board, and then on a town warrant if the select board asks to do so. That's how you would change an ordinance. I don't think that's necessary here because this is an allowed use right now.
Well, I guess that's where a little bit of my confusion comes in. I did review the video from that 2019 appeal. I actually reviewed it twice. Read the decision, finding of facts that came out from that board. And as I reviewed that and listened to that, the property owners did go to the Zoning Board of Appeals looking to get a conditional use for purposes of renting the property as a private event venue. And the ZBA determined that that particular use was not an allowed use of the property. So you have, from what I'm seeing, the ZBA specifically stating you would like to rent your property, you'd like to rent it for private, events. We're saying that this just does not fit with what the town of Raymond says would be a, valid use.
I think if that's the interpretation, my understanding of what the board did at that time was specifically look at the ordinance. Is the words wedding venue, function hall, whatever you want to call it, let's have that big umbrella of uses as a venue hall, function hall. Is that listed as a conditional or permitted use? No, it's not. Okay, let's take that interpretation. If that's the closed world interpretation we're going to have, there is not a single wedding going on in this town ever. Not in any district. Is that the intent of the ordinance? I would think not.
For the event that happened at the end of August of 2024, what specifically was that event?
Sorry, can you repeat one more time?
Sure. The notice of violation is in reference to an event that happened at the end of August of 2024. What specifically was that event?
My understanding in the pictures with the NOV is just it was a wedding. Had a tent outside.
Was that wedding done in conjunction with a rental of the property?
Absolutely. They rented out the home, they rented out the barn, rented out the grounds. They brought everything in themselves, the people who rented it. Like I said, they rent this property and they rent it as you have run of this property for the day. For the night, they get to stay over in the house.
With regards to the tents that came, or tents, and the porta potty, who did the rental of those items?
The person that rented the property. And if we want to get into some of the CEO exhibits, there's some support of that as well. I want to say that if you give me one moment, I can look at it. If we look at Exhibit D, the last portion of it is, starts with this page, the Roma Farm, and has a picture on the front. You'll look at the services provided on the next page. They list out other people will coordinate the wedding. Other people, they don't provide catering, they don't provide liquor, they don't provide table and chairs, they don't provide porta potties, they don't provide tents. This is just a property rental. Other people are coming in and hosting events at the property. Yes, she has a business. She's an event coordinator. She'll help out if you ask. However, that's not the primary purpose here. It's a property rental. If those people use it to host a party, they're allowed to do so according to your ordinance as an accessory use on the property.
The event parking signs that are in the notice of violation, who placed those signs?
I believe they can state you did place those signs, absolutely, but they're temporary signs. You look at these; they're stick in the ground, post and wire, almost equivalent to a campaign sign sort of thing. They're not park over here, big wooden structures that you would see at a typical wedding hall.
In regards to the wedding itself, what services did the property owners provide or coordinate before, during, and after?
None. If you want to hire them as her separate business to coordinate, but none.
So they had nothing to do other than placing the event signs on the property? That's the only thing they had to do with regards to this wedding?
Yeah. Yes.
When did the property owners start renting the property at 141?
I believe it was about during that renovation. They had a 6-year renovation after they purchased the property in 2002. So right after that, but sporadically.
So from
Let's say from 2008 onwards, they've rented the property out, and people who have rented the property have hosted events. They also host their own events here.
Right.
Which, according to the notice of violation, if they hosted a wedding of their own or their friends, they wouldn't be allowed to do so.
So this creates a point of confusion for me, because when listening to the 2019 ZBA meeting, they indicate that they were coming to the ZBA for purposes of starting something new, which was renting the property. There's no indication that the property had been rented before. In fact, it was implied that it wasn't being rented.
That's not the understanding I had from watching the meeting or reading the documents. The specific documents, I believe the application itself said that they have hosted and rented the property for the odd event, but they wanted to continue to do that, and they wanted the town to recognize that right.
Yeah, I guess, board, if you can set me straight on otherwise, but again, I listened to it twice. I read the documentation and there's no indication whatsoever about prior rental. So, in fact, that application letter states there's nothing new in terms of the use of our land and barn, but what will be different is in terms of being compensated for our use and open for public rental. That was in their application letter. Lot 30. Is that rented as well?
I would have to ask, Todd, is the other lot that you own currently rent?
Parking area.
It would just be a parking area. But I want to point out that the notice of violation doesn't say much about renting the property. It says use of your property as a wedding venue was not a conditional use or a permitted use. That implies that we don't even have to be talking about rentals here. They're just not allowed to use their property for weddings. That's what the town's interpretation says.
Yeah, but again, you're also stating something different from what was provided to the original zoning board of appeals. So,
From the 2019, the
Correct.
notice of violations that we're appealing tonight is the notice of violation just says that the property can't be used for weddings.
yeah, and I believe we'll get to that as well. Again, though, lot 30, is that rented?
It's rented as a part of this whole entire process. For rental of this property can park on that lot next door.
So a rental at 141 not only includes lot 29, but it additionally includes lot 30.
Yes.
So it's a rental of 2 properties. How do the property owners advertise their property as a rental? Airbnb, Expedia?
I believe it's on Facebook. They have a page. And I did provide, the code enforcement officer provided some screenshots of what they have. I also provided, if you click on a link about on that, it says specifically vacation home rental. You're renting out the home, you're renting out the property. Doesn't specifically say for functions. The first page does. You're allowed to have a function here.
Bear with me, guys. When the property is rented, are there contracts that are filled out with regards to the rental?
Yes. That's typical for most Airbnb, things like that.
Are there sections to that rental that are specific to renting the property for private events?
I haven't personally seen the rental contract, but I'd assume it's different for each. Todd, could you weigh in a bit on that?
You're asking.
The contracts that are signed for the rental, do they include sections for hosting of private events by the renters?
Need them to go to the mic?
I think he said it says they have use of the entire property, not specific to any sort of event.
Okay, so nothing specific to the rentals not specific to the private functions. Do the property owners pay any lodging taxes to the state of Maine with regards to these rentals?
My understanding is no.
How many rentals have been done from 2020 through 2024, past 5 years?
If I don't have those answers right now, I can certainly provide those answers to the board. If we needed to provide an accounting, if we had some notice to do that, we can certainly do that.
How about the past year, 2024?
Just one.
Would that be the one at the end of August?
Yes.
Of the rentals that have occurred, have you had any rentals that did not include a private event?
No, the house, it's rented for private events for stay over, and the barn as well. So that's why you'd come to this property. It's not a lakefront property. It's not something like that where you'd come for a vacation other than to host something.
So it's a rental specifically for private events?
It's a residential rental that has a barn as well. You can stay at the property, and that has amenities that certainly allow you to host an event.
And the last question I have for now, there's been references certainly to meetings with the town in 2018 and 2019. Town planner Jim Seymour and Scott Dvorak. Is there any documentation about specifically what was asked, what was said, what was conveyed by the town as what was allowed and what was not allowed?
I have an entire recording of all the meetings, and I have,
Someone can hear.
oh, hi. You could go up and talk. Explain why we actually were there.
Right. So we do have recorded.
I apologize. You just want to state your name and your residence.
My name is Todd Roma. I live at 141 Raymond Hill Road, the appellant. Yes, when we approached Scott Dvorak and had Jim Seymour, we recorded those and documented them as well to make sure we were clear on what was discussed. We had said, you would question the idea of, can we rent our property for weddings? Can we rent our property for private functions? Yes, because we were being harassed by some neighbors. They confirmed that there is nothing that is keeping us from doing that. And also noted, at the time, the late David Maines was in that meeting and pointed out that there are rentals all over Raymond, and which they would not be overseeing. So we did have recorded meetings of that, which we can provide, as well as some documentation with Jim Seymour confirming that there's nothing on the books preventing us from this. At this time, Mr. Murch, if I can also just touch upon that ZBA meeting that we had met with was about the application. Your interpretation, or our interpretation when we came out of there, is that the board could not reconcile the word quasi for our use. It wasn't that they were denying our ability to do these things, but they were just stymieing the application because they didn't know where it fit. Yes. And the reason that we went there was because we've been harassed by neighbors who threatened to keep us from being able to use our property. As yes, it was prodded on by Scott Dvorak at the time. So he's the one that led us in this direction. If you look at that ZBA meeting, we were never made aware of any opposition letters. We were never made aware of anything. We had gone into that meeting with Scott Dvorak's advice, thinking that this was a formality. And Joanne Simpson also had talked to us that this was just a formality. When we got into that meeting, we were pretty much blindsided by our neighbors, and as well as some letters that were given in opposition. We were never given any sort of heads up that this was going to be the case. So I just want to give you a little bit more background there, that ZBA meeting could have changed as well had we been given kind of equitable treatment on the process itself. We had followed Scott Dvorak's advice. In the end, they denied the application, and then we received a letter from Scott Dvorak saying we could not have any weddings. Didn't say private, didn't say anything. It just said weddings. We then went back and copied Scott Dvorak and the town attorney asking for clarification, and have never received anything from that.
I'm Jessica Dobson, Todd's wife, and I just wanted to reiterate what he's saying. We went to the town, we asked what we're doing, is this legal or not, because we were getting threatened by our neighbors who we were in a lawsuit with. They all looked at the books and said, there's nothing on the books that says you can't do this. And we left that meeting, and then in February, the year later, we heard from another neighbor that they were going to try to ban weddings in Raymond. So we asked for a meeting with Jim Seymour and Scott Dvorak. Can I come talk to you again? So we sat down with them again. We said, look, are they going to ban weddings in Raymond? And he said, it's been talked, there might be something, but you'd be grandfathered in no matter what. And I said, well, can we just get something on the books, because I'm sick of being threatened. And he said, I don't know what we could put you under. And Jim's like, I don't know. And then Scott said, well, what about a conditional use permit? And we said, what is that? And he said, well, we'll put you under a quasi-use. And I said, okay, what do we need to do? He said, you need to pay this amount of money, and then you would fill out this form, and then you'd go in front of the board. And we said, do we need a lawyer? And he's like, no, we don't have anything on the books against what you're doing. So this would actually be a good stepping stone to put something on the books for anyone in the future. You're the first person that actually admitted what they're doing in this town. And so we signed that day, and you can see from the paperwork, we gave you a check that day. We signed that day. Scott gave us the information. We had no idea what we were getting into. We were just like, okay, we'll put it on the books. What do we need to do? He said, you'll need someone from the state to come and inspect your property for electrical. You'll need someone to come for the fire and safety. And we said, okay, we'll do all of it. Anything we can do to stop being harassed by these neighbors who were a contractor behind us being allowed to go on a residential property. And we were in a lawsuit with, and we were just scared. I had already been assaulted on our property by the neighbor. Our yard was torn up. The town wasn't helping us. Chris Hansen had already let them do what they wanted to do, so we were scared. And so we fell into this, and then when they came and did the site walk, we talked to Joanne. I said, is this a permit we have to pay every week? I mean, every year? And she laughed and she said, no, that's just a one-time fee. And I said, well, what if someone shows up to this meeting, like our neighbors behind us, who don't like us? And what if they say, we don't want them to have this? Are we going to get, not the permit? And she said, no, I'm looking around your property. There's nothing here that you're violating for land use ordinance. And everyone already rents their property in Raymond. So we went into that meeting. We were never informed there was any opposing letters. We thought Kathy was our friend. Come to find out she wasn't. You can even see in the meeting that I cry because I can't believe she's there to read a 6-page letter of proposal, because we had been asking her, can you sign this petition that we had, which all our neighbors signed, and she kept saying she was busy. We didn't know she didn't like us because she used to be our friend. So I have no idea what changed with her. She always knew that we hosted functions. She had no problem with it. All of a sudden, she hated us. I have no idea what flipped on her, but something did. So she shows up, reads a 6-page letter of proposal, just citing the stuff that we had no idea what she was even talking about. And then the other opposing people were all relatives to the people we were suing. The whole thing was like an ambush. And then Scott sat here and we're like, Scott, you brought us here, stand up for us. And he's like, I don't know, whatever you guys decide. And they couldn't decide what the use of quasi actually meant. So Joanne's like, I don't want to upset neighbors. Denied based on the fact that we can't agree on what quasi means. And we're like, what? Literally, why would we go into asking for a permit for this, something that we didn't even know what type of permit it was? Why would we go in if there was ever a chance we were going to get shut down to never rent our property or host a wedding again? We wouldn't. That's just silliness. So we literally were led into this thinking that we were doing right by the town and giving you guys a chance to put something on the books for wedding venues. And we were fine with helping to do that. We were also told we'd be grandfathered in if you ever came up with an ordinance against it. So we were totally blindsided by the whole thing. I was blindsided by Kathy. We were blindsided. So we left that meeting why did we show up to this? We were already told by the town, as on my recording I have on my phone, from everyone that we met with saying, Jess, there's nothing on the books against this. The town of Raymond lets everyone rent properties. We're never gonna, we don't keep track of that. And you can have private functions on your property. And so the fact that we're here now and we're reliving what we went through back then is just insanity. We're not commercial. We don't rent our property every day of the week. Most of the time, most of my functions are for friends and family. We enjoy our property, and everyone loves the beauty of it. And the good part is that we own 45 acres on the top of Raymond Hill that we're preserving. And we're preserving the farmhouse and the barn for our kids, for all these people to come. Everyone here is for us, by the way, that's sitting here, just so you know. And they're all here to support us because they love what we do for this town. And the fact that we're standing here because Kathy all of a sudden doesn't like us, and she obviously has a lot of free time on her hands because she's also writing an ordinance against everyone else in this town, that she wants to be in control of who can and can't rent their properties because she doesn't like it. I just don't understand why we're even here, but that's what that whole ZBA meeting was about. So you can watch it and rewatch it, but you can see me crying in it, and you can see us shocked about what's happening and the fact Scott isn't even standing up to help us. We were blindsided. We would never have walked into something without a lawyer, I could have got 20 times the amount of people in this room to support us that day. But I didn't think I needed it because we were told we were just doing right by the town, and they're going to use us as a spring point to show you know, if anyone ever else comes to them, this is what. And we were willing to let you guys put conditions on us. We didn't have to ask for that. And we were like, okay, let's do right by the town and get something on the books. So, anyway, I'm done.
Okay.
Who else wants to talk?
Thank you, and I do appreciate the comments. I do have more questions, but I'm gonna pause for now and leave it to my,
And I wear sunglasses
Board members.
because I've had 2 brain surgeries and I have light sensitivity, so don't think I'm just trying to be cool here. Sorry. They just want you to know.
So Pete and Tom, you're on Zoom, so if you're gonna wanna to ask questions, please just say, hey, this is Tom, I wanna ask a question, or hey, this is Pete. But I'm gonna turn it over to you guys for now, please.
I'll go. So the owners of the property, when it's being rented, are they present generally during the duration of the rental?
Not unless they're required to be there.
Okay. What would be an instance of their
If they have to
requirement?
coordinate something, like I said, that she does run a coordinated business as well.
Okay. And then I know that this is a different standard as has been pointed out, but you did mention in your in point 3 in conflict of interest. I believe, I think you said that Chris was working hand in hand with the Raymond SPR ordinance. Do you have, what's the evidence of that?
And
Can you point to your submission?
The website.
Can you, is there something?
I don't have
Okay.
anything in the submission. I can provide that information if you'd like, though. And I think the code enforcement officer can certainly tell us in what way he's helped out with that as well.
Well, I guess I'll ask him when he's speaking, but I suspect you know, he'll have an answer. And then I had a question for Attorney Hamer, actually. Is it appropriate to ask that now about, I want to ask about the previous ZBA video.
Yeah, of
and
course.
what the level of consideration we should give to watching that video, where it's not actually evidence that's been presented to us. I thought there's some material associated with that appeal. And I know, David, you've mentioned it a couple times, and it seems to be a keystone point to your questioning. And I just want to understand, is that something the board, the video footage, is that something the board should be considering today? Or can you give me some guidance on that, please?
Sure. Well, the board shouldn't be taking ex parte evidence. So it's good that if people have reviewed materials, that you put it on the record now to let everyone know exactly what's been viewed, so that everyone has the opportunity to review and to comment on the same material.
Okay.
The prior zoning board decision is, I believe, submitted as part of the record.
Yes.
So that's already in the record. So I guess if the town wanted to ask to have that recording be part of the record, then it could be entered as evidence for what it's worth. And certainly that would be the appropriate thing to do if that's going to be any basis of your decision making.
Okay.
Yeah, I just
Go
want
ahead.
to.
No, yep.
As part of the ZBA decision, Attorney Hamer, it does say reference to the it does say refer to the recording to get the full, take of what happened at the meeting. So that, it was based on the fact that in the decision, it makes reference to the video, so it sort of led to that. So it feels like it's already
Sure.
a part of the submission, but.
Well, to make sure that it's clear, then I think it should be made explicitly part of the record.
Yep.
It certainly is reasonable to have it as part of the record. It certainly is it's relevant, so I don't see any problem with it. Just want to make sure that it's clear, and if any of the parties need time to review that recording, I think then they should probably be given the opportunity to do that, since it's a last-minute submission.
I just 1 second. I mean, I just want to be upfront. I have not reviewed that as thoroughly as I think perhaps some other people have. And if it's going to be a threshold issue or an issue to decision making, I think that I'd love to review it, or maybe we can play parts of it that we think are material, or I don't know what the solution is for there. I just wanted to bring that up because it seems like that's an important point.
If I could comment, I would say that the prior ZBA meeting really doesn't have much bearing here. We do mention it because it's part of the history of this property. However, it was a different question at issue for the ZBA there. I mean, that's specifically a conditional use permit. Here, we're appealing a notice of violation. I think the arguments that we make here are clear ways that this notice can be rescinded. The prior ZBA hearing having really disputed a different issue and being denied on a different issue, whether it was a conditional use at all, really doesn't have any bearing on the decision this board has to make. We certainly should consider it as part of the history of this property, understanding that specifically that wasn't the issue in front of the board. Was it a conditional use? And can they issue a conditional use permit? Like I said, I don't believe they could because it's not listed as a conditional use.
My only concern is that if there has been some discussion about what was, or representations about what occurred in that hearing, that the best source of evidence is the recording so that you can actually hear and confirm that the issue before the board was restricted to the issue of conditional use. Because if you look at the actual decision letter, it suggests that perhaps it's broader than just conditional use. And so I think that perhaps reviewing the materials and the recording might be one way to answer that question.
Mr. Chair, if I may.
Yeah.
So certainly, the CEO, the town doesn't have any objection to including the video. It's a public record, and it's and notwithstanding what Attorney Skolnick is arguing here, our position is that it is incredibly relevant to the decision you're looking at today, and in fact, that the board's findings as to the nature of the use and the fact that that decision became final is incredibly important as a legal matter in determining now whether a violation exists in your ordinance. So I think Attorney Hamer has pointed out, anytime the board is relying on something to help inform your decision, properly that should come in as part of the record. Given here that it is relevant, it sounds like at least some members have reviewed that document and that the appellants were present at the hearing. We would certainly not object and would in fact insist that video become part of the record.
Yeah, I think that the difference is the decision versus the video, and the fidelity that the video yields might be lend much more, guidance or even facts that could be useful. And so
and we'll speak to the significance of that decision when we present our case. I think as a general matter though, just in terms of this being a de novo review, the board is entitled to look at whatever evidence it feels it ought to look at to help inform its decision, as long as that evidence becomes part of the public record. To my mind, the board is doing everything that it should be here in terms of its review.
And I would add, I do agree. I don't object to the video being entered into the evidence. I would just remind the board that they can weigh whatever evidence that's in the record and make a determination based on that evidence.
So Attorney Hamer, is there an action item on our end at this point now to get that video into the record, or is just discussion significant enough or relevant enough to do that?
I think that you should just take a vote to have the video added to the record, and that should be fine.
Okay, thank you. So I'll make a motion to include the video archive of the 2019 July ZBA meeting regarding the appeal.
So moved.
Included. Second it. All those in favor? David Murch. Any discussion? Yes. Sorry.
So entering it in the record, does that mean that we're going to play parts of it for the public as well, or what is just?
I guess Attorney Hamer can clarify, but at a minimum, we can acknowledge that the video is out there and use it in terms of our decision-making process. Whether or not we show portions of that video tonight or leave it for later for review.
Just to help clarify, perhaps, it's evidence that you can rely upon, the same as any of the written materials. Given it's the fact that perhaps not everyone has seen it, it might make sense to allow people the opportunity to review it. It's already a public record, so the public would have access to it already. So it's just a matter if the board feels it needs to review the recording in closer detail, then you may need to take some time to do that.
Okay.
If you feel you have all the evidence you need from it, then you can. It's just the same as any other document that you would rely upon.
Okay.
Well, I guess we have a motion. It's been seconded, and there's a discussion, but I probably got the order of operations a little bit wrong, but I do think that if there's a material point to be made, I know there's other people that are talking. I think it'd be prudent to at least highlight that in the video today as part of the proceedings. Is that an okay suggestion, like direction to head, Attorney Hamer?
Sure, that's fine. The town's attorney perhaps can try to do that for you. That could be a question to the town. If they know, if they haven't reviewed it and they're not familiar with it, then it may be the kind of thing that you'd have to review at a later time and then reconvene. I hate to have a part two, but if it's necessary, it's necessary.
I think it just matters if there's something that hinges on watching it. I don't.
Right.
Yeah.
At least now, we'll have the motion to bring it into the record.
Okay.
If we feel, as we go through this.
Yep.
The
Fair.
presentations.
Fair.
Great.
Okay.
Good.
Yep.
All
Sorry.
right. No, it's all right. That's what we're all supposed to do. So all those in favor of the motion of bringing in the 2019 video archive. David Murch, yes.
Greg Dean, yes.
Fred Miller, yes.
B. Lockwood, yes.
Tom Hennessy, yes.
Okay. Have more questions, Greg?
Forgot it was my questioning period here.
You can always come back.
Yeah, I'll yield for now and listen.
Right now, I don't have any. I mean, I have a lot of them in my head right now, but I want to hear a lot more so that I can put it all back together.
Yeah.
I just need more information.
Of course. Pete or Tom, do you have any questions for the appellants? Pete?
Yeah, David, I was just wondering, in the original decision with the ZBA, one of the things they considered was the, excuse me, the comprehensive plan at the time. And knowing that we now have a new comprehensive plan for the town of Raymond, I'm just wondering if there's an opportunity here for us to see things a little bit differently, depending on what that the new comprehensive plan has come to conclusion.
I can answer that. It hasn't been voted on.
Yeah, so if you want to speak to that.
So I would just, and certainly your own counsel can chime in here as well, but and the prior decision, I think, got into this as well. The comprehensive plan is really a strategic document and not one that carries the force of an ordinance. The ordinances are adopted in conformity with a comprehensive plan, but when we're talking about whether or not a use is allowed or not allowed, the comprehensive plan doesn't speak to those issues. So I would say certainly as a legislative exercise, looking at the town's comp plan is certainly warranted. But I would say in this instance where we're really focused on whether or not a violation of your ordinance exists, the comprehensive plan wouldn't be something that would speak directly to that issue. And wasn't something that ultimately, I think the record of the previous decision, my colleague Phil Saucier, who was here at the time, I think talked through with the board that ultimately the decision that the board was considering was something separate than the comprehensive plan that was on the book. So even if it had changed, I think the decision would stand on its own merits.
And I concur with that. The comprehensive plan is not the enforceable ordinance, it's the land use ordinance.
Attorney Skolnick, would you be?
No, I agree with that as well. Like I said, I do believe, based on the ordinance itself and the land use ordinance that applies to this property in the district, that this would be an allowed use. So I think you can move forward separate from the determination back in 2019 and make your own de novo interpretation with all the information that's in front of you tonight, that this is an allowed use of the property. But I as well would like to hear from opposing counsel and members of the public. I think one of the worst things we can do is table this hearing, wait for anything else, and have these people not here to speak.
Yep. Tom, did you, oh, sorry, Pete, did that, do you have any other questions, or is that?
No, I'm good for now, David, and I appreciate the discussion.
Okay. Tom?
No, I think I'd like to hear from Chris Hansen and that side of the audience.
Okay.
Before I ask anything.
Very good. Attorney Skolnick, you all good to go for now?
Thank you very much.
Okay. Code enforcements?
Yeah, so I'll start off here and just talk through some of the legal arguments that have been presented to you. We do have Chris Hansen here, the code enforcement officer. I am more than happy to let him talk through what he observed on the site, the basis for his own determination that a violation exists here, and I would encourage the board to discuss those factual issues of what was observed on the site, what formed the basis of those decisions, to discuss those with Chris directly. However, there are several arguments that the appellants are making here that bear some further discussion and clarification. As we already discussed, the constitutional issues and equitable estoppel are really off the table. They're not things that are relevant to the review here. A rare instance of it seems like every attorney in the room agrees with that. So just to reiterate, those issues are simply not properly before you. The question is, fortunately, a narrow one, and it is simply, is the use that is being undertaken on this property permitted in the ordinances, or is that use undertaken in violation of those ordinances? The Code Enforcement Office determined that the use that was observed violates the town's ordinances. This is a unique situation, or a unique case, because it's rare to have these kind of questions of the type of use that a property is to have already been discussed at length and subject to a decision. Here, as has already been pointed out, this property was subject to a 2019 application for a conditional use. The decision and the documentation that is in the record before you demonstrates that what the appellants brought before the ZBA in 2019 is virtually identical to what they are describing today as the ongoing use of this property. This board in 2019 affirmatively determined, and I can look at the motion here, and this is, I believe, exhibit D of the town's exhibits, a copy of the ZBA decision denying the conditional use permit. The Roma Dobson application must be, motion made that the Roma Dobson application be denied as conditional use due to the inability to find a suitable conditional or permitted use in the zone RR4D3 that fits with the type of business that will be run at the residence. The board, based on the four corners of this decision, determined that the use proposed by the applicant and now the appellants here is not one that is either permitted as right or permitted as conditional use in this district. The appellants had an opportunity, if they disagreed with that decision, to appeal the Zoning Board of Appeals decision back in 2019. As their attorney has already told you, they did not do that. This decision is final. And when you have a final decision that, as against a party that was a party to that previous decision, we call that, in the legal field, something is, res judicata, which is just a fancy Latin way of saying, we have already decided on this issue, and you can't now try to change that final decision when you already had an opportunity to make those arguments in the past. The applicant and the appellant here had an opportunity in 2019, and they took that opportunity to argue that the uses that they are trying to undertake on this property are allowed in the town's ordinances. The board affirmatively determined that they are not. And that is a final decision that does control the legal question, not necessarily the factual question of whether the violation actually is ongoing, but it does control the legal question as to whether the event space wedding venue use, as described by the applicants, whether it is a permitted or allowed conditional use on the property. That question has been settled against the appellants here already. And the answer, therefore, is no, it is not allowed. And the question remaining now is, as a factual matter, are they doing it anyway, in light of that decision that this is not permitted or an allowed conditional use for which a permit would be required? Chris will be able to speak to the observations that were undertaken. Ultimately here, based on the comments that you've received from the appellants tonight, they don't seem to dispute that this use has been ongoing for years, has been ongoing in the nature that they're describing, and that the denial in 2019 didn't really slow their roll when it came to undertaking this use on the property, notwithstanding that denial. The Code Enforcement Office is required to respond to complaints it receives. It's required to apply the facts and observations that are undertaken by the code enforcement officer to the ordinances that are in effect. And that's exactly what happened here. The question of equal protection, that constitutional question that was raised by the appellant, as we've already said, that's not before you tonight. But this is not a case in which this property owner, they have not shown any indication that they are being maliciously singled out by the town here. The Code Enforcement Office was responding to a complaint, and in light of a public decision that this use was not permitted on the property. The record shows an ongoing effort by the Code Enforcement Office to communicate to the property owners here, reminding them of that past decision, warning them that continuing to undertake this use is a violation of the ordinance, and they continue to do it anyway. That formed the basis of the NOV that ultimately resulted in the appeal today. And I do want to speak to the legal arguments. So there's been a lot of discussion here tonight of rental uses being allowed in the town of Raymond. That's true. Rental uses are. A rental is just it's a form of ownership, right? The case law that Attorney Skolnick is citing stands for the simple proposition that if someone is renting a house as a residential use, that's fine. Someone renting an apartment is not a commercial use, right? It's a fundamentally residential use in nature. The fact that it's a rental is incidental. Chair Murch, one of your questions got to this point, I think, pretty incisively, which is it's not the fact that it's a rental, it is the underlying type of use that the rental is being undertaken for that is at issue here. That use is a wedding venue and an ongoing commercial venture. It's telling here that according to the appellants, the property is owned by a commercial entity, this LLC. The record that you have before you, the LLC formation paperwork, sets out the purposes of that business. It's as described by the appellants. As they note, the business is focused on events and consulting and organizing around those events. That seems to be consistent with everything that's been said here today. I'll credit the appellants for not trying to hide those facts, because they are apparent. That means that the question here before you is straightforward and much simpler than has been presented thus far, which is simply, has that use continued? You have documentary evidence indicating that it has been. You have testimony from the appellants themselves saying that it has been, and that should settle the factual question. The last piece that I wanted to touch on was this question of whether it was an accessory use to an underlying residential use. Assuming that it is true, as the appellants indicate, that they use this residence, this property, as a residence in addition to this use. As their own attorney laid out in his filing to you, the term accessory use has a specific meaning in your ordinance, and it has a specific set of meanings and principles behind it that courts have further elaborated on. And I would point you to the filing that the appellant's own attorney made, because I think this language is incredibly useful. So this is on page, let's see, on page, on page 2 of that filing, under the first bullet point. And I'll read it to you here. Maine's law court has recognized that an accessory use is lawful if it is dependent on a principal use, dependent on a principal use, has a reasonable relationship to that primary use, and is customarily associated with it. By that rubric, this is clearly not an accessory use. This wedding venue is not dependent on the use of this property as a residence. It is, in fact, distinct from that. Its use as a residence, in fact, may be a hindrance, potentially, to that underlying use. Setting aside here that, as has been indicated already to you tonight, this use is so significant that it has subsumed the use of an adjacent property here that does not contain a residence. That, in and of itself, an accessory use cannot exist on a separate parcel. It has to be incidental to a principal use on that parcel. Now, the violation you have before you is related to the main parcel here that contains the structures, but it's relevant here that the record clearly indicates and is not contested that this supposedly accessory use is one that is so substantial that it has started to swallow land around this existing parcel. So I would like you to keep those things in mind as you think through these issues here. I'm happy to discuss. Folks, I gave you all the respect to not interrupt you when your side was speaking. I would ask for the same courtesy. Thank you.
Yeah, Attorney, I don't disagree with you, but if you have concerns, bring them to me and I'll bring them to them.
My apologies, Mr. Chair.
Okay.
That's really all I have to say. I'm happy to answer any questions on these specific legal issues that were raised in terms of the interpretations of the ordinance, the effect of this 2019 decision, and any of those issues that were raised in the supplemental briefing by the appellant's attorney. But I would, at this point, just encourage CEO Hansen to talk through the facts that led to the drafting of this NOV and answer any questions that the board has on those factual bases.
Okay, Chris Hansen, Code Enforcement Officer for the town of Raymond. I have been familiar with this property since probably the early 2000s when the Romans bought the property. I issued a permit to them to do some renovations to their home and worked with them through that process. One of the things that's brought up is that the barn is an accessory use to the principal use of the home, and it was mentioned by the attorney for them, Mr. Skolnick, mentioned that they did renovations to the house and the barn. Unfortunately, I cannot find anything in our your building file that says you got any permits to do any work to the barn. Did you get any permits that I'm unaware of for the barn? And what were those permits? You let them answer after?
Go ahead, you can
So-
present that as a question that needs to be considered.
Okay, that's a question that needs to be answered. So I'm going to go through my submissions, the exhibits, and I'm going to do it in reverse order because it goes back to when they got their business license application, and I guess it was dated 2/25/19. It was denied due to their ZBA application for conditional use. That's Exhibit H. Don't have a lot to say about that. But as a result of their...
If I just interrupt you for one moment, please. I do not have an Exhibit H in my packet. Is that something that could be provided?
Absolutely.
Thank you.
The next exhibit is Exhibit G. And it's a letter from the fire inspector. He was asked to do an inspection during the conditional use appeal for things that would be required if they got the conditional use. Specifically, it addressed emergency access through the site, exit signs, fire extinguishers, electrical systems need to be brought up to the electrical code, street address need to be posted, square footage of the proposed wedding barn, installation of a fire alarm system, all buildings requirement fire alarm system have a Knox box, et cetera, et cetera. I don't believe these things were ever done. Am I correct? You can answer that later. Exhibit F is the letter from Mr. Dvorak issuing you a warning after you've been denied the conditional appeal that if you continued, it would be in violation of that decision. Exhibit E is an event that happened at your farm on August 13th, 2022, a wedding for the Patels and the Arsenals. This was a post, I believe, on Facebook, and shows pictures of the barn used for the wedding and ways to contact the Roma farm about this venue. Exhibit D is my warning letter and a copy of the ZBA decision denying the conditional use permit. Exhibit C is a website screenshot with photos from Catherine Plummer on the event that was the actual violation, which was, excuse me, I gotta get to that. On August 29th, 24. There's also a screenshot that Jason Williamson, the assistant CEO, found showing the tent going up, which led us to believe that there was a proposed wedding happening at the site. That weekend of the event, I personally went there on a Saturday, took pictures of the event assigned parking, which directed people to park on the abutting property, Lot 30. I'd like to point out the other thing about the Lot 30 is there is no principal use on that property right now. The building has been vacant and abandoned. Nobody's living in it, so there is no principal use. So a parking on that would be the only use if it's used as parking, which it was. And then the notice violation with pictures and copy of the LLC license, Exhibit A, which we've already discussed, that states that they do decorating, consulting, and vendor coordinating, as well as leasing their property for wedding venues. I guess I'd be open to questions after that.
Were you working hand in hand with the Raymond STR ordinance?
No.
And there was a reference to relatives. Can you elaborate on the relationship that might have been referenced?
I have no relation to the horse farm up on Raymond Hill. I know him. I've known him for years, but I'm not related to him in any way.
Okay. Can you explain what an accessory use, what an acceptable, like give a few examples of what an accessory use on
Accessory
that
use would be
principal use would be.
if you have a residential use, that's your principal use. In fact, that's what their principal use is. You could have a shed, that would be an accessory use. You could have a barn as an accessory use. But within those accessory dwellings, structures, they would still have to be a permitted use if it's used for, let's say they were using it as for storage. That would be an allowed use, is permitted. Wedding venue or auto repair business or a grocery store in one of those accessory buildings is not a permitted use and wouldn't be allowed by the land use ordinance. That's why I believe Scott Dvorak directed them to go apply for conditional use. Conditional uses allow somebody to something that's not listed as a permitted use to go before the ZBA, and if the ZBA determines that it could be allowed as a conditional use, the reason they call it a conditional use is so that they can put conditions on it, like hours of operation, parking. It could have conditions of noise. There's all kinds of things that the board could put on it for condition. The fact is, they went to the board denied that, and they didn't have any conditions because it's not a conditional use. I guess that's my answer to that question.
And sorry, and I would just add to that, there are listed principal uses within the zone, including home occupations, and I think it's worthwhile to look at what is actually permitted in the zone. And I would encourage the board to check out, I believe it's section 300 point dash 9.2 that sets out what a home occupation is. It's very limited, right? We're talking about something that's carried on wholly within the dwelling or within the structure, has very, very specific operational requirements. So the ordinance does contemplate that a residence can be used for a not purely residential use, but the ordinance is also specific about what those have to look like. And a home occupation within the ordinance wouldn't be an accessory use per se. It would be something beyond that, but I would submit that what's being presented to you today is beyond even what a home occupation would allow. The definition within the ordinance talks about it being incidental to that principal use. And as Chris said, there are plenty of uses that are not directly using something as a residence. Growing vegetables in your backyard. That's something that's accessory to that residential use. It's incidental. Hosting weddings as a seasonal event coordinated space is not that.
So I know when this all first started way back in the beginning, right? There was no restrictions or conditions on what they were doing to make that not correct for them to do it. Is that correct?
I'm not sure how you're,
So in other words, when they came to the town, right, asking for guidance where they were being, somebody was bringing concerns to them about what they were doing. And Scott at the time said, well, we don't really have any provisions for that. So at that point, were they doing something against the town's ordinances, or were they not?
I believe that they were in conflict with the land use ordinance because it was not a permitted use and they hadn't got a conditional use permit.
So that states that, it stated that back in our ordinances back then?
Yes,
It did.
that hasn't changed.
So I guess I missed that somewhere. So, and then above and beyond that, after their meetings of the different things, the only thing that has been added is what the fire did with all, putting the signs, that 24-hour notice, if you're gonna have an event, making sure you have, for the fire department, so they know they can have rescue you, say if they need them, or, they know they got a big event coming up. So them are new conditions that was added since.
Those would have been, if it was a permitted use, they still would have had to bring the barn up to code if they were gonna use the barn. And that's what
Right,
Wayne's
right.
referring to.
Right.
In other words, that's an assembly use group. If they have 100 people in that barn, we wanna make sure the people are safe. We haven't had an opportunity to get those things done because they haven't applied for a permit to do those things.
Correct.
There isn't a fire alarm system. There isn't a sprinkler system. There isn't bathroom facilities. Those are all things that we consider when somebody has an assembly use group. We haven't talked about the building code or the fire codes that Wayne is referring to, but those are something in addition that if it was a permitted use and they came to get a permit, we'd instruct them, these are the things you need to do. For a conditional permit, same thing. That's why Wayne addressed that when this came up as a conditional use. Those things, to my knowledge, were not followed up on. Whether that was because they didn't get the conditional use, I don't know. But, the interest of the town is to make sure people that go to these events are safe. And we haven't been able to weigh in on that. If somebody's holding an event privately on their property, which they had done in the past, and they do that, invite people to their home, they take that liability. But when you invite people in from, whether it's quasi-public or private public, we don't need to get into that because the ZBA already weighed in on that. But the people that go to that building, whether it's inside their home or inside the barn or in a tent, have the right to be safe. And that's our job as public officials, code officers, and different officials like Jim Seymour, the planner. Those are the kind of things that we address on a daily basis, but that's never been done. So not only is this a land use violation, they're also in violation of our building codes and our fire codes, because none of those things have been addressed. So it's just a point that's in the file, and I would say that because they didn't appeal their conditional use to Superior Court, it just got dropped. And then, we don't go looking for violations of people having weddings at their property. We act on, if there's a complaint, we go investigate it. And the abutters have rights too. And if they're complaining of noise and activities going on their property, it's my job to investigate. So that's what I did. It's also my job as the code enforcement officer to enforce decisions by the ZBA. And the decision that was made that they didn't have the conditional use, that's why I'm enforcing this. I have no racehorse in this race. I'm doing my job, and I feel that there's been some accusations that I'm doing this out of some affiliation with the neighbors. I've never been to the neighbor's house. I've never met with them, other than she's asked some questions about activities going on at the property adjacent to her, and she has concerns. I get that. And it's my job to investigate those. So we did. And Jason has done the same thing. I didn't step aside because there's no reason to. I don't need to recuse myself. I don't have any conflict of interest here. I'm just doing my job.
So Fred, at the end of that fire and rescue memo, item 9 says, this is Wayne Jones, as a condition of approval, the Fire and Rescue Department asked the Raymond Zoning Board of Appeals to consider requiring the applicant owner to bring the proposed facility into compliance with the state and local adopted fire protection and life safety codes and ordinances. So that's where this.
I would like to add a couple more things if I could. So there is some materials supplied by the Romas that they inquired Scott Dvorak to expand on his decision. And looking at that, I believe it's, see if I can find that. Remember where that was, the letter? It was an email from the Romers to Scott, but there's no record of that email in the file. Typically, if we get an email with questions about property, we put a copy in the file. I didn't find that in the file, and when I looked at the email, it was sent from Todd to Jessica, but it doesn't have any other addresses on the email, so I'm assuming that that just went to Jessica and it never went to the town at all. So my point is that they've had opportunities with Scott's warning letter, to follow up. They've had the opportunity to follow up with my letter that I sent certified in regular mail, and there was no correspondence with them asking any questions about why I sent the letter of warning. The next thing I know, they're having weddings again, and so what Jason and I observed on the Saturday before the wedding on Sunday was a tent erected, portable toilets, the parking signs. It looked to me like there was definitely going to be a wedding on the following day. I went with Jason on one occasion. He went separately, and I went separately and took pictures, which are provided in the packet of exhibits. So, you know, they definitely have had weddings there. There was a question of why I didn't approach them at the time when we noticed that the signs were going up and when the tent was up on a Saturday. Well, there was no violation until the wedding happened on Sunday. And the other thing is, in respect to somebody that just rented the property to have a wedding there, didn't want to ruin a bride and groom's wedding day, because they had no knowledge that this wasn't an approved conditional use or permitted use. They just were going by the advertisements that said it's a wedding venue. So why would I want to ruin somebody's wedding? So I think that might clear up why I didn't stop in and have a conversation. The other thing is, typically when people rent a property out as a vacation rental, they don't stay at the property during the event. So, you know, I wouldn't have had any idea that they were there. I would have just assumed that it's the people that rented the property setting up for the wedding.
So to clarify one of your points, Chris, in regards to Mr. Roma's email, in Exhibit D, there's a forward from Phil Saucier, which does include the original send-tos. So CEO at Raymond, Maine, Mary Quirk at Raymond, Maine, J. Seymour at Sebago Technics, and Phil Saucier. So it did go to town officials.
Oh, it did?
Yeah.
My apologies.
Well, I should say, yeah, it did go to the town as well as interested
Where
parties.
did you see that?
It's in Exhibit D. There's a email, the top of the email is from Phil Saucier, but as you scroll down it, you can see Mr. Roma's email from February 5th. It's kind of, I don't know, this is what you're looking for.
Yeah, I got it.
With the board?
We will give you opportunity to do that before the public comment, yeah. Did you have any more, Fred?
No, thank you.
Pete, any questions?
I think I'm good for right now, David. Thank you.
Sure. Tom, any questions?
Nope, I am good.
Yeah, only questions I really had were already answered. Why was there a delayed response? The delayed time frame with regards to the August 29th to the time when it was the email, the notice of violation was actually provided, but you answered that you didn't go on property that day. Why was it a 60-day time frame from when pictures were taken, wedding was confirmed versus, the notice of violation being sent?
Volume of work, number one.
Yep.
We had other appeals going. 2, short-staffed. That's when Alex had left. I had hired Jason, which he was totally green, so I was training him. So it was timing.
Is there any, are there any ordinances or town requirements, the timeframes when something's noticed to the time for which a notice of event is, or notice of violation is sent?
No.
Yeah, and my other question, which appears we don't have an answer to, is why there was no town response to Mr. Roma's February 2020 email, but.
I can answer that. I'm not
Yeah,
a
'cause
scholar.
Right, I understand that you guys weren't there, but it would have been nice to know that. Okay, yeah, Attorney Skolnick.
Thank you very much. I do want to try and take these, I was taking notes as I was listening. I want to try and take these things one at a time if I can. And please fill in if there are any questions that you need me to answer as well. I do want to address the decision by the 2019 zoning board. Attorney Burns did go through it. However, I do disagree with some of the things he said, and I know that you folks know that we're going to have 2 interpretations of almost everything you hear. So, sorry. Let me flip to that. Attorney Burns, can you tell me which exhibit that you were referencing? Sorry.
Attorney Skolnick, I believe that is in Exhibit
I think it's
toward the end.
throughout a few times. So I do have one thing. Attorney Burns made reference that this decision, it specifically said they couldn't find anything any suitable conditional or permitted uses in the zone. Assuming that they looked at accessory structures and uses, right? I think if you keep reading in that sentence, that fits the type of business that will be run at the residence. I think we addressed that this is a residential property. Even Attorney Burns said that renting out a residential property, yes, we have said that people hold functions at the barn. It's a perfect place to do it, but this is an entire property rental. They're renting out the principal use, which is the home as well. This is not a business if you're renting out a residential property. Jessica does not conduct her business of coordination and providing flowers to all of the people that are there. They can separately hire her to do so if they want to. This says that you can't hold a wedding venue business, and there's no specific use for that. However, this is a residential use. This is a residential property that has a perfect area to host weddings, and that's what they're doing. So I do disagree with what Attorney Burns said, that the prior CEO decision already addressed this, because I don't think it did. I think there's a clear other interpretation that's right in front of this board that you can find that this is a perfectly allowed use at the site. Additionally, I think there is a question here that wasn't asked to CEO Hansen, and it's, since you said that there's no weddings allowed at the site, where in town can you hold a wedding? Where can a property be rented out to hold a wedding? Absolutely nowhere in the town of Raymond can you host a wedding, or somebody else can't host a wedding at a property.
Are you asking me?
So I'm going to pause that. You
I'm
need
not
to
gonna
ask your
ask-
questions to me.
Absolutely, I'm not going to
However,
ask you.
I don't want a significant back and forth here, but I do think this is a significant talking point, so I would like to hear response specifically to that question.
So the ordinance lays out, and sorry,
Go ahead.
don't want to jump on you here, but I mean the ordinance lays out specifically in certain zones that service establishments, retail businesses, commercial operations are permitted, whether as permitted uses or otherwise. A commercial use is permitted in your district, in your town, in commercial districts. So it's simply untrue that there's nowhere in this town where you can lawfully hold a wedding. The point here is that you cannot operate a commercial wedding venue business in this zone because it is not a permitted or conditional use. Commercial uses are permitted elsewhere in the district, in the town, and this would be a commercial use.
I would agree with that. So, to expand on that a little bit, you can have a wedding in a church. We have weddings in churches. We have weddings at some of the camps around the lakes. You mentioned Kingsley Pine and Tamanis. They've been holding weddings there for years. That's a commercial operation in the shoreline zone, which is grandfathered. They've been in operation since the 1800s. It's a little different than a brand-new commercial business in a residential zone.
I think we have a disagreement whether this is a commercial use specifically. And like I've been saying, we think this is a residential property that is rented out like many other areas in the town, and that people can hold functions at the barn. And I'd also ask the board to ask CEO Hansen if he was aware of any of the 4 weddings that took place just down the road in the rural residential zone that he did not issue a notice of violation for at Tim Davidson's property, who he did claim that he's been acquaintances with for a long amount of time. I also want to clarify one point that
I'm going to
Attorney...
pause for a second. At this point, I don't know if we need to go down that road simply for the fact that Mr. Hansen has indicated that he investigates complaints and doesn't search out actual violations. So.
I also do want to address one more thing that Attorney Burns said regarding the separate property next door, and I believe it's lot 30 next to lot 29. This is used for spillover parking. The argument here that it's now a principal use that it's parking on that property. Simple fix. If the town wanted us to fix it, we can simply deed that property into the same name as the Roma LLC, and those properties are merged together, and that problem dissipates. It's really not a hard fix, and thank you for pointing that out. If this board determines that this is an accessory use, that's what they can do and easily fix that issue. And bear with me for one moment. I was taking quick notes as they were speaking. I do want to say one thing about the definition of accessory and what the law court said, that it's dependent on that use. Like I said, Attorney Burns is skewing, I believe, in his favor, as he should, one of the primary purpose of this property, and it's a house rental, seasonal house rental, like I keep saying, with a barn that can be used for functions. The home and the residence is part of the property that is rented. CEO Hansen specifically said that he did not know that people were staying there. How could he? I understand that, but I'm telling you right now on the record that the home is rented out with the barn. It is not a separate, you only rent the barn use here. The whole property is, including the residence. Therefore, this is accessory to the residential use. There's also a few things here that were mentioned. Our CEO Hansen looked at our clients and they said, oh, are you in violation with your barn of building codes? That is not on appeal here. We are not looking for new violations to find. And if anything, I think that points out to singling out these folks even more. I'm not going to go down that road. However, one thing that said where the fire chief is looking for fire code improvements, we're not looking for a violation there. If the town said they were allowed to do it, they'll happily meet all of those requirements. However, the town's sitting up here telling them they're not allowed to do it, so why would they go and revise, renovate a barn at all and seek further approvals for something that the town's not gonna let them do? Were there permits pulled for the barn? That's also not under review tonight, and it's certainly inappropriate to bring up at this meeting whether new violations coming later on. And I did want to point out, and thank you for pointing out, that email after the 2019 meeting, hoping for the town to clarify exactly what the zoning board's decision was and what they are allowed to do, just remained unanswered for 4 years now. CEO Hansen said that only one person from the town might have received it, or the town never received it. I think we can all see that almost every person that was involved, CEO, planner, attorneys at the time, everyone received that email, and it was just left unanswered. I'd be happy for more questions from the board or to let these people from the public speak as well.
I just need help reconciling, 'cause you had mentioned about deeding the property at Aroma Farm LLC, but then I'm also hearing this is not a commercial venture. I'm having a hard time reconciling Aroma Farm LLC with what's happening with the property.
So there's many properties that someone has an LLC and they are renting out the property, and they simply just want to take liability out of their personal name and put it into an LLC, which is a limited liability company. You can't go after the individual, you can go after the corporate entity. There's many real estate LLCs that happen. These folks, they have an LLC, it might have been filed the wrong way, or they only had one LLC and they put this property in that LLC. Simple mistake, and something that can easily be fixed. Most people who rent out properties, whether it's residential purposes, commercial purposes, and I'm not even considering that for this comment, most people who rent out properties put their property into an LLC. Any attorney in this room, I think, would advise their clients to do the same.
Yeah, I just, again, I'm trying to reconcile it with the character of the business, event space rentals with decoration consultant and vendor coordinating. That's all. Just trying to piece it together with whether it's an actual residential rental of the home versus, yeah, rental specific to events. That's all. Just trying to reconcile it, how it pieces. One other question, and I bring it up simply because it was, it's a significant part of the ongoing letters that were sent from CEOs to the appellants, as well as in the notice of violation, and it's in regards to the advertising of a wedding venue. The code enforcement does have in their exhibits an example from end of August of the Facebook site specifically indicating a wedding venue, and then we have evidence as well that it has since changed. So there is evidence stating that there is advertisement of a wedding venue. So I'm just curious, when did it change and why?
To address the town's concerns, if that was one of the town's concerns, that it simply advertises only a wedding venue, then we wanted to more accurately represent the project, the property of the town. This is a home rental, and the website says that specifically. It's a home rental that you can have functions at, and that's the position we've taken, and I think that's the only way this board can look at this property.
That's fine. It's just this was written in a way that makes you think that it never advertised it as a wedding venue. But so it was advertising it as a wedding venue at the time of
it was
August event. Is that correct?
You certainly may. Sure.
So the Roma Farm has a Facebook page, and you can clearly see in the first one, it's when it states what we are, it says property rental under it. It's just, Facebook makes you, when I made that way back, I don't know what year I put that Facebook page out. We had it under wedding so people could find me because I also sell flowers. I do arrangements. I'm a wedding coordinator outside of our property. It was a way for people to find some of my work that I do. So it clearly stated for the property use was rental property, seasonal rental property. So then when we got this strange violation notice, one of the things that we did, I was like, oh, I didn't even see it said, like, if that's a problem, which I didn't think that was illegal in the town of Raymond, I just switched it to say, I think it says now property rental. So, and Facebook isn't an advertisement, it's my Facebook page for my flowers that we do sell from the property, for if you want to rent the property. So that's what that's about. Is that clear? Or?
Oh, it is. I'm just, again,
Yeah.
I'm just trying to match it up
Yeah.
with what.
Yeah,
is in
so
the
it was just.
Documentation.
That had been there for, I don't know, whatever year I put together a Facebook page. So, which is at least 10 years ago. Okay? Thank
Yep, thank you.
Excuse me.
Did code enforcement have any follow-up?
Can I ask one more question? just to
Of course,
clarify
yeah.
what-
Yeah,
what
yeah.
your wise
Yep,
here?
yep.
You answered this already. I just want to double check the answer. In the last year, there was one rental, and that's
Yes.
the rental we're questioning today.
Yes.
Okay.
Code enforcement, do you have any?
The only thing I'd follow up with is in the Facebook page where Scott sent with his violation letter. It says that they have an all-inclusive package as follows. This is off their Facebook. Wedding ceremony and reception, including a 3-hour rehearsal. Wedding coordinating, overnight stays, setup, decorating, cleaning, trash removal, use the farmhouse and bridal suite. You have availability for the groomsmen, ceremony. Day of the wedding will include parking attendants to help direct your guests. You have full use of the grounds. I guess that, to me, sounds more like details that they provide a lot more than just renting the home.
I could respond, and as we've been saying, Jessica runs that business where you can hire her as well to do some of these things, wedding coordination on the side. It has nothing to do with the business. It's not a requirement of you to, when you rent out this property, to have any of those services from Jessica's wedding coordination business. It's certainly something that they'll provide, and she'll provide for an extra fee from her other business, though.
So I just got one other question, probably for code enforcement, but I want to make sure it's your understanding as well. And we've got so much documentation with regards to rentals and private events and weddings and such. And those can be combined in several ways. I want to make sure I'm understanding correctly what we're looking at here is, but I'm going to ask code enforcement first, and I'll pivot to you. But as I read all of this, I want to make sure this is correct. Code enforcement is saying that it is okay to have a private, I'll say weddings for now. It's okay to have a wedding on your property for family and friends without charging a fee. It is also okay to short-term rental your home, your residence, for stays. But if I'm hearing all this correctly, it's not okay with regards to this property to rent your property for purposes of having a wedding. Is that a correct understanding?
I believe you're correct.
Yes.
Does that match your understanding?
It's not my understanding. It's certainly my understanding that that's their interpretation of the ordinance. I believe what they're saying is in the rural zone, the rural residential zone, you cannot rent your property, and the person who rents your property can never host a party, a wedding, a function of any kind. Even doesn't matter if you advertise it as such or not. They can't use the property for anything other than staying the night.
Okay. Board members, any final questions for these two parties?
Just
Well,
wondering what-
no, go
I was
ahead.
wondering if our attorney should bring in onto this a little bit, what we were just talking about right here.
Go ahead and ask Fred.
Your attorney, Hammer, the question we just brought up and we're just talking about, do you have any input onto that?
I think that at the end of the hearing, you're gonna have to make some determinations about what the nature of the use is. And based on the factual findings, then you're gonna have to decide those issues. Those seem to be the real question, is this allowed by the ordinance or not? And once you determine what the use is, then that's gonna be your call. That's the ultimate issue. Unless I'm talking about a different issue, but,
No.
No, I think you've got it correct, Mr. Hammer. Okay.
To provide a bit of clarification, just to build on that, I think our position would be, hopefully this board will find that we are permitted accessory use, and renting out properties is allowed, and use of those amenities on the property, such as the barn here, would be a permitted accessory use, to make it easy for the board.
Good. Thank you. So I'm going to open things up for public comment. Now, clearly it's getting a little bit later, and I know there's a lot of people here. I'm going to encourage you to speak either on behalf of the application first, and then those who are against the application secondly, and those who are neutral to the application can speak then. I'm going to start first and at each of those levels here for people who are here in the audience, then I'll open it up to people who are out on Zoom, so there's no confusion. I will ask, though, that you keep your comments brief. We give our parties as much time as they need to present their case to us, but when it comes to public comment, we like to keep things a little bit shorter. So please limit your responses to 5 minutes or less. If you hear a party has made a comment that matches very much like yours, you can please just say, I'd like to echo the sentiments, or I'd like to reiterate whatever this person said. This is also my take on it. That way we can shorten up the public comment. That doesn't shorten the effectiveness of your comment. Please know that. It just makes it so we can get through these a little bit quicker. So I will open up public comments now. If there's anybody here who would like to speak in favor of this appeal, please go up to the podium, the microphone, state your name, your residence. I think there's a sign-up sheet up there. If there is, we need to have people signing in on that as well.
I
There
don't
isn't?
see anything.
Okay. So,
I'm happy to sign in if there is one, but
Well,
I
if
just
there's
see
not one.
maps and masks.
yeah, we're good. As long as you state your name and then specifically, I know I said this is for, but I need to hear you specifically state whether you're for or against or neutral.
Sure. My name is Sarah Davis, and I am speaking in support of the appellants and hope that you find that this notice of violation should be dismissed. I live at 85 Tenny Hill Road. For those of you who don't know, that means I drive up and down Raymond Hill all day long to bring my kids to school at Jordan Small and at Wyndham High School. I have known the Romas for a few years now. Our kids go to school together. I have attended private events at the Roma farm. I have dropped and picked off kids at their residence where they clearly live 365 days a year. The primary use of this lot is clearly residential. I'm speaking mostly here as a Raymond landowner. I think it's really important that land rights be protected in the town of Raymond. As a landowner myself,
I get concerned when I hear things like putting up a tent or a porta potty could put me in violation of an ordinance. I think that you need to read this ordinance in the light most favorable to landowners. I think this is clearly an accessory use because it is their residence. You heard there was one event in 2024 that there was some overstatement by the attorney. I was listening the entire time, even though I couldn't be here on Zoom. There was some overstatement about how excessive this use was and how they didn't slow their roll. One event, I think we all can appreciate, that's not a business that would survive very long if that was all that you were doing for a business. So I think the facts have been severely distorted. I'm incredibly troubled by the idea that you only could receive a notice of violation if your neighbors are bothersome and seem to call in. I have also driven by the many events that happen on Raymond Hill. I've seen tents and wedding venues go on. The sign was right there. I actually thought it was really cute and took a picture of it, advertising weddings at other venues. So the idea that you somehow needed a complaint that wasn't visible to every resident in the town of Raymond, clearly outside the town office, is just not true. I know that you're not supposed to consider the equal protection under the Constitution. I'm an attorney myself. I appreciate that you're not here to decide constitutional matters. You do have an obligation to treat everyone in the town of Raymond fairly, equally, and apply your ordinances in a manner that is fair to all of us. And a decision here tonight could have a negative impact on everyone in this town with respect to how we're able to use our property. And that is incredibly concerning to me. Thank you.
Thank you.
Hi, Heidi Lawler. I'm in favor of this process to, sorry, I don't know the proper terminology. I'm in favor of the Romas being able to continue. I was just curious as to what prompted, I know the complaint prompted the violation, but before sending out that letter, what was the proof that this was a rented wedding versus just a wedding that was thrown?
So at this point, we're here to hear your comments. We're not
Okay.
really here to answer any specific questions,
Sure.
whatever you
Okay.
heard within this.
Okay. I definitely echo what she says. Super supportive. Never seen too much going on over there other than like family, friends, and just a lot of fun respecting all the other Raymond residents. Thank you.
And do you mind can you just?
Yeah, sorry.
No, you're good. I know there's a whole bunch of stuff to remember. Just your residence.
Raymond. Me.
Okay.
My name is Michael Foster. I'm a Gray resident. I'm here in support of the Romas. I'm a small business owner based out of Portland, Maine, and I'm fortunate enough to call Todd and Jessica and their family longtime friends. My following comments will be based strictly on a professional business related level. My company delivers ice and refrigerated trailers across the state of Maine and beyond to all events, to include weddings, graduations, festivals, fairs, anniversaries, and sporting events. These venues range from large stadiums, commercial restaurants and buildings, dedicated event venues, and even small private single family dwellings. Over the past 15 plus years, I have seen almost every venue in this lovely state we live in. In fact, I am both surprised and excited to have the opportunity to deliver to new venues and to see different corners and nooks of our home state. On our busiest weekends, we can deliver over 20,000 pounds of ice to all these locations. Our delivery route has taken us to several places in the Lakes region, to include several locations in the town of Raymond over the years. Again, from beautiful farms, such as the Romas, to semi-commercial feeling rental properties, to the small private single-family dwellings and residences. Many of these locations would make use of their existing infrastructures, buildings existing on property already, while others would use temporary tents, awnings, porta potties, or the becoming more popular porta potty trailers, which are a little bit more pleasant to use. The Roma farm has always been different. Their gatherings seem to follow a set of rules and guidelines that seems to ensure that they are good stewards to both their guests as well as their neighbors, I'm sure. From their reclaimed granite steps to their sprawling landscapes and beautiful flower gardens, it's a beautiful property preserving, history. And they pay attention to the details. I can honestly say most venues we deliver to, and again, I've been to several, lack these, making it seem far, far closer to a not owner-operated, more commercial, simply just an income revenue for them. And that's much different at the Roma farm. In fact, I would dare to say that the way the Romas operate could be used as a model, not as a target, and should be used for future considerations and examples. On a personal note, I have been blessed to witness the Romas' journey from the start to the present day. Through their struggles and successes, I've been in attendance to some of their events, private events, and my wife and I have even had the pleasure of privately hosting our own daughter's high school graduation and college send-off years ago at the Roma farm. We chose their location from many options available. Their first-class operation, who should be looked at as an example. There are years that I deliver to Raymond addresses a dozen or more times a summer for weddings, for parties, for events. It's what I do. So again, I would echo the comments earlier about land use and restricting this as part of my business. It's part of what I do. I'd hate to see it go away. But more specifically, it is happening. It's happening frequently. It's happening all throughout this town. And it just seems unfair to me that it seems as if perhaps this notice of violation went specifically to one and not to others. And that's my comments. I appreciate your time. Thank you.
Thank you.
My name is Tim Davison. I hang around Raymond, and I am not a lawyer. You got enough of them here tonight. I don't know the Romas. I don't really care to. I know enough people. I am the one who did not have 4 events last year. It was only 3. It's not commercial. I don't charge. And I will mirror the fact that I think they should be able to do what they want, and I have a real problem with land restriction. Past my bedtime.
Thank you very much.
Oh, one final thing. He was not related to me. He married my cousin. Big mistake.
He's great about both things.
I'm Aniko Pongratz. I live on Webbs Mills Road, right here in Raymond. And we've been here since 2003. And we started our family here, and kids went through Raymond schools, love them. Went into Wyndham. They're in college. They're doing great. I love this town. It makes me very, very sad to see what I see as a targeted attack on this incredible family. I mean, it is obvious to me. I'm sitting here listening to the attorney and to all these people go after this family, who is an amazing family and does wonderful things for Raymond. The events that they host are classy, they are safe, they are respectful to their neighbors, and the fact that one person can complain and cause this stink makes me angry. I live here, I want to live here for a long time. I love this place, and I'm really disappointed, frankly. I hope that you all go home tonight and think about that, because we love living here too, and they have every right to do what everybody else can do. And you're nitpicking little things that you know are like just to, ooh, how can we get them? That's what it sounds like to me. I hope that you can reconsider and allow them to have their rental property, or however you want to call it. It's clear what's going on. Thank you.
Thank you.
My name is Genevieve Abrams. I have a home in Wyndham and a home in Raymond. I'm glad I came to this meeting. There's been 5 weddings, all kinds of anniversary parties held in Raymond on the lake. Had no idea that there was any issue with that. And I've been to several parties at the Romas. And what I see going on here, this town, I don't know how, with what you're saying is a violation now, I don't know how you could ever enforce that except for doing what you're doing right now. And that is, Jessica Dobson has had 2 brain surgeries. This is doing a very awful thing to her. And this town is responsible for causing all this stress. And her neighbor, I hosted a party at her home for my husband's 75th birthday party. It was a surprise party. There were probably 70 people in that barn. We drove up. There wasn't a car. You couldn't see a car. All of those cars were parked down on that property, way down in back, not taking over anybody's land, not consuming the land. They've done a terrific job with that land. That home, before Todd redid it, was falling down. The barn was falling down. The property that they just bought is going to be fixed. Todd and Jess they've been very involved in Raymond schools, coaches. They're decent, upstanding people. And for you to single them out because the neighbor, we drove up to that. You wouldn't have known.
I recognize there's a lot of
You wouldn't have
tenseness
known
here.
there was a party going on there.
Okay, as long as we can keep this focused on.
The tent is on the other side of the
Facts.
barn. The porta potty's on the other side of the barn. It's a huge property. You can't even, my husband didn't see a car, didn't see a person. They were in the barn. So I've been to several things. They're Halloween parties. They're all very well done. They're very considerate of everybody. There's no cars parked on the street. On Deep Cove, all those weddings and those parties, the cars are all over the place. The neighbors are nice enough to let you use their space to park, or they're on the street. I had no idea you couldn't have a wedding in Raymond. This is just, well, actually, the town needs to they need to clarify some things. And if they're going to do it for one person, they've got to make sure that they're able to uphold this for everybody, not just for one person. Thank you.
Thank you. I'm just going to pause for a minute. I recognize that, this can be some tenseness here, but what I don't want is, I don't want anybody to vilify Mr. Roma and his wife, Ms. Dobson. I don't want anybody to vilify code enforcement. So and I also don't want to tone down your emotions either. Please convey what needs to be conveyed, but don't use that as a methodology to attack anybody here, please.
I wasn't attacking you.
I know, but it seemed to be getting close. I was getting a little uncomfortable. I don't want anybody attacking them. I don't want anybody attacking them. I don't want to be attacking us. I just want to be able to get information out there. Have your emotions, definitely. I'm putting this forward as guidelines moving forward. I don't disagree. Craig?
Well, I think, just to clarify, I think they can say what, we should give them time and they can say what they want to say.
Right.
And
I don't disagree. I want to hear what you have to say, but it feels at times there's bordering of attacks on people here. I don't want people here to be attacked. Is really what I'm trying to get out there. I'm not trying to say that you attacked, okay? I just want to have good constructive feedback. If there's emotion behind it, I want to hear that too. You have every right to be upset about a situation. There's no question about that. But I just don't want that to translate into attacks on anybody that's here. That's all I'm trying to convey.
David, this is Tom.
Yep.
Just comment from the Zoom side here.
Sure.
This is a business meeting, so I get that people have feelings, but this is still a business meeting. So we're trying to accomplish a goal in the end and come to a decision. So control the emotions would be a great idea.
I think we should have council ring in on that. This is a municipal proceeding. Yep. I don't know if we can restrict and counsel people. I don't think we should be restricting speech, I guess. And so if Mr. Hamer can comment on what the guidance we can give public, I think maybe time, and we can ask for it to be civil, but I don't think that I'm not trying to, it's a concern that I think we should weigh in with council.
Sure. This is a public proceeding, and it's a governmental function So people do need to restrain themselves and act in a civil manner toward each other. They're free to offer whatever public comments they want. If they become disruptive, then you can ask them to stop or tone it down, or if absolutely necessary, they could be removed from the venue. But for the most part, as long as people are being civil, there's no problem with having them speak with emotion. But I do think it is appropriate to maintain appropriate order in the proceeding. There's a certain amount of decorum that's required of the meeting.
Thank you, Mr. Hamer.
Good evening. My name is Alan Abrams. I'm from Wyndham. And I just wanted to say that I've known the Dobson family since high school. And they're a wonderful family. And I met Todd when he and Jess became an item. I just, I know they bought that rundown farm, and they've done a tremendous amount of work there. And if they say they had gone to the town and got approval to do these things, they want to make sure they're doing everything the right way. They weren't, as far as I can see, they weren't trying to hide anything. But I know I've been to a lot of parties at their house. As my wife said, she had a surprise party for my 75th birthday. And my grandkids have gone to parties there for years, and we've had a wonderful time. And I would love to have them as a neighbor of mine. They've taken a property that was really run down, and they've done nothing but improve it. And I mean, I would love to have somebody like that. Their place is immaculate at all times. The house is nice. The yard is always clean up. They got flowers. The fact that Todd bought that extra lot, he parks the cars out there, is better than having them park on Raymond Hill Road, because that's a fairly busy road. He's put the time and the money into making sure that everything is right. He's got a nice place to park the cars. I know. I think it's a win-win situation for everybody to let them do what they're doing. They got permission from what I understand, pretty much got permission to do what they wanted to do, and based on what they heard, there was no ordinance against it. They went ahead and put the work and the money into improving their property. I think that's going to be seriously taken into consideration. Thank you.
Thank you.
Hi, my name is Amanda Buxton. I live at 28 Swans Road, so just off the bottom of Raymond Hill. I'm in favor of this notice of violation being rescinded. I'll keep it brief. Sarah Davis summed it up beautifully, both I think as someone who's associated with the family, who's been to events there, and as a landowner in the neighborhood. Absolutely in favor of them, being able to continue doing this. I don't think it harms the land. I don't think that any disruption to abutters or neighbors is any different than any other event that's held up and down Raymond Hill, all around all the various lakes at any time. So, that's it.
Thank you. Is there anybody else here in attendance in this building that would like to speak for this application? Is there anybody in Zoom that would like to speak in favor of this application?
Make sure we have Sandy. Okay, I do insert her video froze.
Yeah, I'll say one more time because I know Zoom can sometimes not be as good as we like. Is there anybody out there watching via Zoom that would like to speak in favor of this application? Okay. So we're going to pivot now to, is there anybody in this room that would like to speak in opposition to this appeal?
Good evening. My name is Brian Rayback. I'm a land use lawyer with Pierce Atwood. We represent the direct abutters, Catherine and David Plummer. We are here in support of the town. We respectfully ask the board to reject the appeal. Lawyers like to make things complicated. That's a lot of what we do. I'm going to try tonight, however, to make this a little simpler. This is not about constitutional arguments. It's not about estoppel. It's not about whether the neighbors get along. It's not about whether someone else, somewhere else, can hold a wedding. It's not about whether you'd like the event or not. It's not about whether the CEO worked on a rental ordinance. It's not about whether the town answered an email. What it's about is whether the appellants have met their burden of showing that the NOV is wrong about how they're using the property. That's the nub of this case. So, first, the nature of their activities, in our view, is clearly prohibited under the zoning ordinance and this board's decision, and they do not get to relitigate that now. You do not get a second bite at the apple. That's the common folks' way of saying res judicata, the Latin phrase you heard earlier. Okay? I think the decision is broader from this board than what's been discussed tonight. It's not just about whether you could hold weddings. The board, right in the first paragraph, says they would like to hold a few seasonal events from July to the first week of October. And then the examples they give are bridal showers, weddings, wedding renewals, birthday parties, each year at the property as additional income. I think the board understood that it wasn't just about weddings, it was about these kinds of it was a private event venue, right? The board then went through that analysis, decided that wasn't a permitted use, and it didn't qualify as a conditional use. That's not unusual. There's all kinds of uses that aren't allowed in Maine zoning districts all over the state, right? One of my clients is a bottled water company. Just about every town we go to for a new spring site for them, we have to deal with the fact that the ordinance never says anything about a spring site. And so often what the solution is to amend the ordinance to make it clear, right? Lots of other things aren't listed. A nuclear facility, right? That's not listed anywhere in town. Does that surprise us? No, of course not. Now, is a nuclear facility and a wedding event venue the same thing? No, I'm not trying to say that, okay? But it is not surprising that there are lots of uses that are simply not allowed in a zoning ordinance. Now, the second point, the thrust of what I hear the Roma Farm appeal to be is that they now prefer to call their private event business something else, short-term rentals. But what you call it doesn't change what it actually is, right? This isn't a typical Airbnb situation where different families rent the house for a week at a time and they come stay there rather than going to a hotel. People aren't typically staying over. They're hosting a series of large private events to make money, like weddings, which require rental tents, caterers, DJs, parking, etc., right? Mom and dad aren't setting up a little tent in the backyard for the kids to hold a little birthday party. That's not what we're talking about. That's not what's listed in the notice of violation. This is much bigger than that. These are hired businesses who do this for a living. They bring in tents and DJs and food and all these kinds of different facilities. It doesn't become a different use just because they call it a short-term rental, right? Or because they don't hire the caterer, right? That would be like saying if they rented the house out to a cannabis business, is it okay for the cannabis business to sell pot out of that house? No, of course not. What matters isn't that they rented the house out. What matters is what is the actual use going on at the property. And I think it's pretty clear that these are private events. And this board has already said, in my view, you can't do that. In short, we asked the board to reject the appeal. We understand it's an emotional issue. It's emotional for our side too, right? It's a difficult issue, and we appreciate that people have different perspectives on it, different levels of emotion on it. My request of you is that you try to strip the emotion out of it and figure out simply the nub of this question, which is whether they've met their burden of proving that the allegation in the NOV is wrong. Thank you.
Thank you. Is there anyone else here in the building that would like to speak in opposition to this appeal? Is there anybody out in Zoom that would like to speak in opposition to this appeal? Again, is there anybody out in Zoom that would like to speak in opposition to this appeal? Is there anybody in this room that would like to speak just from a neutral perspective in regards to this appeal?
Can I just say, I gotta say one more thing.
Sure.
Not gonna be, deep breath. So I don't know if anybody over here or anywhere besides the town folks went into the application for the appeal. But if you go in there, there's a statement by Todd, and he lists out what's going on and what they're doing and so on. And I love the fact that shortly thereafter, he says, well, let me give you some history. There's history here. And that history is important. It's connecting to the dots to why this is even happening. Because why is it that one person, so everybody can do what they want in Raymond unless one person complains, seems a little bit fishy to me and it doesn't seem fair. And so here we are, boiling down to the little, terms and so on, and totally ruining this an amazing family's, life. And so I urge everybody, including the board, I'm sure you've all done it, but to read that history and see why we're standing here, because to me it was very clear. It was very clear. I feel like the papers need to be notified that this is what's happening. Now, that being said, I respect the time that you've all put into this. I know it's your job to do this, but I really urge you to look at that history and see why this family's being attacked, because that's exactly what's happening. And I think everybody knows it. One person causing us to be here. And there's a history. And actually, one more thing, I thought Raymond was about less regulation, and here we are piling it on. It just doesn't seem right. We're here to do what we would like with our land. They're not hurting anybody, including the neighbor. I think we all know that. Less regulation, not more regulation. Thank you.
Thank you.
I was wondering if I could speak in opposing to the appealants.
Certainly. Yeah, just if you can state your name and your address, please.
Yeah, I'm Desiree, and I live at the top of Raymond Hill Road, very close to the appealants, and I would like to oppose them. I would like to express my deep concern about the ongoing violations of conditional use by my neighbors. It's troubling to see that despite, from my understanding, them being denied conditional use, they continue to host events in clear disregard to the 2019 decision. As others have shared personal connections, I feel compelled to do the same. I am raising my young daughter here in town, in an area surrounded by farm animals and families who value the peace and quiet of rural living. Their actions not only disregard this, but also create unnecessary stress for those of us who live nearby. Every event they host leaves me worried, not just about the noise, but also about the potential danger of someone drinking and driving leaving their events and the potential harm that puts on my child and others in this community. The appellants claim that they are being unfairly targeted, and yet the history that the lady before just brought up is not being fairly assessed. There was harassment of a neighbor who is battling brain cancer, and the appellants even went as far to sue her family after she died. They're harassing 2 elderly neighbors. This kind of behavior raised serious concerns about where their appeal's coming from, as I read their appeal, and they mentioned this neighbor multiple times. Their actions are not just affecting the people, it's affecting the environment and the surrounding farms. Again, they were denied conditional use in 2019 from my understanding, and that's why we're here today, is from the appeal of the violation that they just received in August. They have not considered the effects that these events that they are hosting host on the horse farm right next to them, the cow farm on the other side, or the goats. And what about the many young families who live here? While the noise they're saying from their events is quiet, it does keep my young daughter up and me. But my primary concern is their blatant disregard for the decision that was made. I'm not here to personally attack anyone. It's about the facts. Again, please make me understand if I'm not understanding this correctly, but they were denied conditional use and they continue to operate in violation of that decision. I urge the town to enforce the rules and to protect the integrity of our community. Thank you so much.
Thank you. Desiree, are you said you're a neighbor, are you an abutter?
No, I live across, like right down the road across the street from the horse farm.
Okay, thank you. Is there anyone else in Zoom that would like to speak in regards to this application? So I'm going to go ahead and close public comments. I would like to give the appellants opportunity to speak one last time with regards to anything they may have heard here. I'd like to give code enforcement one last chance to speak with regards to whatever they may have heard. And then we will close the public hearing and move on to board discussion.
Thank you very much for the opportunity to speak again. I'm going to be very brief. There's not much that I really have to address here. I do want to address one or two things. Attorney Rayback said, first off, I think I just want to reiterate our position here that this is not we're not trying to shift the use here. I think that there's another interpretation of the ordinance. I think it's very clear that this is an accessory use of a property. Like you said, it's not a commercial use. This is one event that was hosted last year, a single event. Now everyone's trying to paint this as a business. It's not a business. This is a residential property that is rented out, and there are some events. The property of Tim Davidson, you heard him speak. He hosted 3 there last year. No concern. Not at all. All the other people that spoke here today, they all attended events hosted by the property owner. Jessica Dobson hosted those events. Todd Roma hosted those events. The property wasn't leased out to anybody. If CEO Hansen showed up that day, he would have had no idea that they were the ones hosting the event. Show up one day and there's a tent, it could be anybody there. Majority of the time, it is the property owners. This is not a business. It's an accessory use of their own property, and that's allowed. Thank you.
Code enforcement, any last comment?
I'd like to thank the board for their consideration and patience. As has been said already, the question before you is one that you're applying the facts here to the ordinances. This is not a question of what other individuals in the town may or may not be doing. This is simply a question of applying the ordinances to the facts that have been established here and determining whether or not the appellants have met their burden. We believe, based on the record evidence before you, they have not done that, and in fact, the evidence clearly shows that a violation does exist. Again, thank you for your time. Happy to answer any questions, any final questions you may have as you go into deliberations, and I wish you luck in that process.
Thank you. Well, the appellants were up there. I should have asked. The board, do you have any final question for either the appellants or code enforcement? Attorney Hamer, any last things that I may be missing before I essentially close the public hearing portion of this and move into board discussion?
No, I think everyone has had ample time to have their say, and I think it's time to mull it over and do deliberations.
Okay.
Perhaps after a short break.
Yeah, I would be in favor of a short break as well. So I'm showing at 10:04. Let's just take a quick 5-minute break and give us a chance to do what we gotta do. So our board will reconvene in term reviewing this appeal regarding a notice of violation for having a wedding on 141 Raymond Hill Road. So we're going to move into our deliberations, discussing what we've heard here today.
This is Tom, I have a quick
Tom.
question. According to our bylaws, aren't we supposed to take a vote to continue after 3 hours?
I'll let Greg talk to that since he's the one who wrote them.
I believe it's to bring new business to the table. I think it's to start new business. So I think existing business has a clear path till like midnight, and then we are forced to vote at midnight. I believe. I'm happy to be.
That's my understanding as well, Tom.
Yeah, I did write it, but I'm sorry. I think that's what it is, and if we want to look, we can look it up very quickly if somebody wants to. But I think that's.
Hopefully we resolve this very quickly.
If you want, as a matter of out of an abundance of caution, we can vote and have a unanimous vote. But I think we're good.
I don't think we have to.
Okay.
So I'm pretty sure.
I think you're right, Greg.
Okay. Thanks, Tom.
Would anybody like to start us off?
I still got a little something nagging in the back of my head that I'm trying to wrap it all around. And it's probably just me having a blockage here. But again, none of us were here, well, us here, were at this back in the beginning. And I only have that I can see is from what the appellants gave us for a letter that they had written actually recently on 10/29 of 2024. And it goes in pretty a lot of details, and some of it was talked when they were up there. I'll try to pick a spot, and again, this is what's, I can't get this out of the back of my head on this violation, and I just like to ask again about maybe some more clarification of it, because again, we weren't there, I weren't there. But they had a situation that they talked a little bit about with the neighbor, and they came to the town, and it's about halfway down on the third page of that letter. And I don't really know the starts where we initially went to the town during this awful time in our lives, and first in 2017 and again in 2018. And we asked if we could get something in writing or on the books to rent our barn for wedding or our property for other events. We were told in our first 2 recorded meetings that they were not violating any land use ordinances, and they couldn't find anything on the books prohibiting what we are already doing on our property. They stated no one had ever come to them to ask them, and again, this is them talking to us, ask us for this, and they couldn't find any prohibiting wedding venues. They told us this was a seasonal town and they do not monitor property rentals, nor could they see them ever doing that in Raymond. We had a follow-up email with CEO and Jim Sigmore a few months later. During this meeting, Scott mentioned, well, if you insist on getting something on the books, what about a conditional use permit? We were aware, and he explained that we technically don't fall under it for use, but he could ask the town to consider a quasi use. We asked what would we need to do to get this, and told us we needed to pay a fee to them and then write a letter to the board and to the abutting neighbors about what we were asking for. He reiterated that we are not violating any town ordinances by doing what we are already doing, but it would be a good way to get something on the books and good for the town to be able to put conditions on us. We would like a template in case anyone else ever asked for this. Scott knew exactly what we were asking for this. He assured us it was a good idea, and we left that meeting handing him a check for the conditional use permit. We left there knowing we're allowing the town to provide to us to bend the law for contractors to have a chance to put conditions on us, and we didn't even have to be asked for. But we're scared and drained from the mental and physical blah, blah. At this time, the day of the site walk, Joanna and Len came to the property with Scott Dvorak. We had already had the town fire and safety come to the property and inspect. We had Scott himself inspect to make sure everything was to code, as well as the state electrical inspector. We had passed all inspections. The other two members of the zoning board never came to the property or even drove by. During the site walk, Joanne mentioned how wonderful it would see the whole barn restored and how much land we had and space not to bothersome to any neighbors. We asked Joanne, as we walked our property point blank, that if our neighbor to whom we were in a lawsuit wrote a letter opposing it, would we not get the permit? She told us, honestly, you are not violating any land use ordinances doing what you are already doing. Unless they can prove you are violating a land use ordinance, I do not see any problem with this going through. You are asking for us to put conditions on you that you don't even need to ask for. I don't think your neighbors would be happy about that. I would think your neighbors would be happy about that. We went on to ask this, how this works. Would we pay a yearly fee, which was mentioned earlier? And she said, no, this is one-time fee. We would not just be deciding on what conditions we would put on you if you are issued a permit. We left the site walk meeting confident that we had not done the right thing for ourselves and the town. And we asked Scott if we should fill the room with the people who support us. We were told no, which we heard this earlier in the things. So I guess the part I'm having a hard time wrapping my head around is, at this point, it sounds like there's not an ordinance violation. But again, this is one side. I went here, and I don't know. So I'm just trying to wrap my head around what is this violation that at that time Scott, Joanne and Len seem to say that there is no violation. Again, they're not here, so I can't ask them that. I need to get that into my head. Am I making sense?
So I can try to fill in a little bit on that for you. In the appeal, the 2019 appeal, we have a letter dated May 20, 2019 from Jessica Dobson, Todd Roma. This was included with the original appeal.
Correct.
When we have this, I'll read a few parts from it. It says, we've already hosted many of these events for friends and family over the past 12 years, from weddings, including our own, to wedding renewals, to birthday parties, Halloween parties, and bridal showers. This will be nothing new in terms of our use of land and barn, but it will be different in terms of being compensated for our use and open for public rental. And then we also have a little bit of fill in the gap for the conversations with Scott and town planner. Our barn was renovated in 2007. During renovation, I apologize, these two-sided printed papers. We proposed our plan to Jim Seymour and Scott Dvorak in January of 2018. At that time, we had a meeting with both of them and the fire safety officer. It was concluded from the meeting that they didn't have an ordinance or permit to put us under, as we are the first to have asked to do this in our town. We had the meeting to make sure that what we planned to do was compliant with the town codes before we continued our renovations and got our hopes up to offer this service to the public on our property. We were assured that there was nothing on the town's books to say that we could not do this type of functions. They posed just having us do an amusement ordinance permit when we do have a function. It has been over a year. Then we contacted Jim and Scott again to make sure there is still nothing new pending with town codes or ordinances. Our most recent meeting on April 5th, which would have been April 5th, 2019, we were told that the zoning board approval for a conditional use permit is what we need to pursue now to become compliant. This brings us to the reason for this letter.
But again, there's not someone saying any violation, right? That they're not. I guess I need to, I got to get it in my head.
Well, I know that, and I think that's one of the main problems I have with the conversations with Scott and the town planner is that there really is nothing was written, so we can't clearly see what was asked and what was said was actually okay to do.
Well, that's what I'm saying. That's why it's so hard for me to get my head into that, because I can't hear, I get this story, but I don't know that story. You
I know, and that's what I have a hard time reconciling,
So, I
as
mean,
well as what specifically was okay, which is why part of my questions are, was it okay to rent property? Was it okay to have private functions for family and friends? And then there's that third one in the middle, renting your property for purposes of private events. That, based on the decision from the ZBA, that seems to be what they went to the ZBA for, was to
But that
get
was for a
conditional use.
condition.
A conditional use to
Right,
allow
but
that.
there was no condition. If they didn't go to them, there was no condition thing that had to be gone for.
But the,
Am I losing something here? Just explain to me, because they're asking for this condition, the town isn't. So until they brought this subject up, there was no violation there to start off with. And they're not getting a denial for the violation because there was no violation. They get a denial because they're asked for a conditional permit, which the town is saying there's no need for a conditional permit because we don't have anything on the books for that. Am I getting this in my head right? That's all I need to know.
yeah, so I can't say that you are or you aren't, but in the decision by the ZBA,
But again, that's only on the condition.
focusing on the condition.
Can our attorney?
Well,
maybe-
hold on, let me go ahead and just read this for you. I'm trying to flush this out, like I had to try and flush it out for myself, which I don't know as I flushed it out. But anyways, the board comments and discussion. Louise Lester expressed her concern, as it is a residential house and nothing like this exists in a rural residential zone. The process seems to be lacking a structural process, as you would find with site plan review. And this is, I think, the key part for me. It says, since they could do what they wish with their property if they did not collect a fee. So it is good that they came to us to try to do this the right way. We could then put various conditions on it if we approved and went through the minimum standards. Then further down, Joanne discussed her concerns about this being a rural residential neighborhood where people have homes or buy homes with the expectation that it is residential, and wouldn't have anticipated a commercial operation based on the zoning ordinances. So this is another key one for me. However, is it possible that this could be approved with extreme conditions and regulations, as Louise had mentioned, so that the activity has some oversight, and then as opposed to continuing what they are doing now without charging money and no oversight? So
Then it says Scott agreed that they could continue as is.
Right, which is continuing as they were doing without charging money.
If I may chime in as well.
Yes, please.
So the Board of Appeals is there to interpret the current zoning ordinance that's in front of you and apply the facts that you find to that ordinance. So a lot of this discussion here might be relevant to the question of equitable estoppel, but that's not a question that's properly before you. There are certainly some representations that were made by prior officials, and there could be a question about whether that was reasonable reliance on those statements. And there's also a question of what was the impact of the subsequent zoning board of appeals denial, zoning board of appeals denial of their application, and whether that cuts off consideration if anything happened prior to the 2019 timeframe. But I think from your point of view, it's a bit more simple than that. I think that what you need to do is make a finding of fact as to what the use is, and then decide whether it's allowed or not under the ordinance that's existing. And a lot of these other issues that have been thrown out there and the facts that support them, that might come into play if there's an appeal. But I think from your point of view, you've got the record, and you don't need to really decide whether there's any estoppel situation where.
Can I ask a clarification?
Yeah, please.
So I think it'd be helpful just to level set on what are the conditions at which this appeal could be upheld? Like are we evaluating this from my understanding is a misinterpretation of ordinances. There's a potential could be a procedural error that I think we've already covered. And then there's a conflict issue which you gave guidance on a higher some sort of higher standard. Is that generally the three ways in which we could move? Because I do think it is daunting.
When you have an appeal to Superior Court of a zoning board decision, the general standard is the court's going to review it for error of law, findings not supported by facts in the record, arbitrary and capriciousness. Those are the three things that they're going to be looking for. And if you have a procedural error that results in a lack of due process for an applicant, that would be an error of law.
Yeah.
If an applicant wants to charge that one of the board members or that there was some other sort of conflict of interest that was weighing in here, that would be a collateral issue that they could address on appeal. But that's not something that you can control at this point. It's not something that you review. But if there was a finding by a court that somebody on the board had a conflict of interest, that could result in vacating of the decision and perhaps a remand. I'm not sure that there's any evidence that really supports the finding that the CEO has any sort of conflict. As he one point said, he was doing his job and he issued a letter, and now you are reviewing his decision. So he could have a conflict, and you are curing any conflict because you are doing a de novo review of his NOV. And if you find that his NOV was appropriate, then that's a new finding, and any conflict that he might have had really doesn't matter at that point because you've said it's an appropriate finding. So I've been talking, and I think I lost my trail.
No, that's fair. Yeah, I mean, I think the conflict is an easy one. I don't think there is one. And to your point, I don't think it matters, because if we had a finding one way or the other, it would be a new finding.
David, this is Tom.
Hey, Tom.
I think we're here to validate whether the notice of violation is correct or not. And the basic thing that the first ZBA came down to was there was nothing in the ordinances that would allow this business enterprise, whatever, whether it's a wedding or other private events, being paid for it. So in my mind, is the violation accurate? because the first ZBA said there wasn't a conditional use allowed in the rural residential area. And then the second part is, did code enforcement pick the right terminology to pinpoint the violations that they were in? That's what's in my mind, I guess.
I mean, it's also entirely possible that the use did change between 2019 and what the I mean, it could be, you know, I think that's definitely possible. You know, the argument that it's a short-term rental, it doesn't seem like that was present in the original application for the conditional use. I mean, they seem to be much more focused on operating an enterprise for a wedding venue, private events, et cetera. And so maybe they took that denial and modified their use in a way that might not be in violation. I'm just trying to, it is possible to disconnect them if it's quite some time and the behavior could change.
But they were also cited with two different warning letters by two different code enforcement officers over the period of time.
Yeah, but we're evaluating a notice of violation for a specific event, right?
Yes, but the warning letters are the same basic operation.
I see.
They were violating the previous ZBA's decision. So they certainly had fair warning that they were in violation for several years. And at this point, Chris Hansen took action. So.
I got to say, I do get tripped up on the fact that it's okay to have a wedding at your house and it's okay to rent your house. But if you rent your house to somebody, it's not okay for them to have a wedding. I'm not saying that's exactly what happened, but that does seem logically inconsistent. Like, I think there are other facts that need to be evaluated. It's not, I'm distilling it down to quite a simple logic statement. That is to me, a hard one to unwind, and if you just look at it just myopically through that lens, you know, I think that you can look at the secretary as you know, I think to your point, Tom, all the other pieces of information lend it to be that it may not be that they were just operating a short-term rental, and that in fact it was a private event rental facility. In this particular case for a wedding. So I can see, you know, I actually find it pretty difficult.
I'm not sure who pointed out that the previous ZBA, they had an opportunity to appeal it. That didn't happen. As a different attorney stepped up, there's always the option of trying to revise the ordinance to allow certain things to happen, and the ordinances are reviewed every year. So I don't know, that's my point of view.
If I may.
Please.
This has been some good discussion, so I don't want to thwart it, but I do think it might be helpful as a preliminary matter for the board to assess the facts about what the use is and make a finding of fact as to what the actual use is. If you find that the use is actually simply a short-term rental and that's it, then maybe you will make different conclusions than if you find the use is actually really a rental venue for events. And that might lead you a different direction. So having a finding of fact as to what you find the use is might be a good place to start. Just a suggestion.
Suggestions are good. Thank you. Well, we do have, I can start with this. We have Attorney Hamer's, I read it initially, definition, well, not Attorney Hamer's, provided by Attorney Hamer of what the Maine's definition of short-term rental is. For the purposes of the municipal role in statewide housing production goals, the term short-term rental means living quarters offered for rental through a transient rental platform. I'll skip the statute citation. The definition of transient rental platform is an electronic or other system, including an internet-based system that allows the owner or occupant of living quarters in the state to offer the living quarters for rental, and that provides a mechanism by which a person may arrange for the rental of the living quarters in exchange for payment to either the owner or occupant to the operator of the system or to another person on behalf of the owner, occupant, or operator. Living quarters offered for rental through a transient rental platform. Yeah, and that was included as
Yeah,
stuff Sandy. But I gotcha.
Greg, when you get done.
And so I do see, I mean, it's the property, we've heard, it's the property that's being rented. With that comes the farmhouse, as well as the property and the barn. But it seems like the primary purpose of the rental, though, is for the barn. It's for the functions. Because the appellants indicated that they didn't have any rentals that didn't include a function. So it's not just for short-term living. That's where I'm trying to wrap around. It's not a rental of the property and then every once in a while there's a wedding that happens in addition. It's always been a rental of the property for the purposes of a private function.
That's a fair point. I mean, I did ask twice to clarify how many times it was rented. I think it'd actually be better fact pattern if it was rented a lot of times for residential use and then one of those residential use just happens to have been a wedding. It would be like, well, right. I think you have a pretty strong argument there. It doesn't, you know, I don't know how you guys feel about that, but that was something I did sort of chime in on. I mean, there's some other ancillary facts that I'm not sure are in one individual super meaningful, but they are suggestive, like the description of the business and from the secretary on the registration with the Secretary of State. Yeah, that doesn't help.
Right. And of course,
that's somewhere here. I've got a sea of papers.
Everywhere.
Yeah, event space rentals with decorating, consultation, and vendor coordinating. I mean, that's not great, in my opinion.
And then the original Facebook intro, this is a rental property for private functions. And the page description is wedding venue.
Yeah.
So, I mean, again, it's, like you said, it's ancillary, but they point towards.
It really is gut-wrenching, because it seems like we're arguing about such minutia on something that happened once. I know that we have to evaluate the facts for the facts, but like, boy.
Oh, sorry.
No, I just, like, I look at it and, you know.
So I know we say once, and I get that because this is for the notice of violation, but there's also, the property owners have indicated that they've done this more than once since 2020, although we didn't get the exact.
Yeah, yeah. I guess my point I was trying to make is I'm just more, it's more of a frustration with, like, I mean, we're just beholden to the ordinances, right? Like, the ordinances, you know, we have the same ordinances, the facts, we have the same facts, but at the same time, it does seem a little bit off. And that's just my, you know, personal opinion. I think we should, like, I go back to that kind of logical problem where it's like, if you own a house, you rent your house, and somebody, you could have a wedding there, but the person that rents your house couldn't have a wedding there. Now, I understand that there's an escalation of that beyond just, you know, once.
Yeah, I follow you. I follow that, but then I get stuck with the only rentals that have ever been done are in conjunction with the private event.
Yeah, I agree.
So Attorney Hamer, I mean, one of the thoughts I have, but I mean, we can go forward and make like a leaning judgment towards this is what we come to a consensus as this is how the property is an apparent use, apparently being, we agree that the property is leaning towards being used in this manner. But then it feels like we have to fall back to the ordinances and review everything under permitted and conditional uses. But then it seems like that work was already done by the original ZBA, was it not? And then we're just doing something we shouldn't do, or is that, I'm not looking at it correctly.
Okay, so yeah, that's a good point. My recommendation was that you make a finding of fact as to what the use is, and then the second part of the equation would be to go through the notice of violation and say, is each provision that's cited, is it appropriate? Is it in error? And so that will necessarily involve an analysis of whether the use that you found to exist is permitted or not permitted or conditionally permitted in the rural residential district. And if you find that it's permitted, then the notice of violation was issued in error. If you find that it's not, then it was issued appropriately. Once you've gone through that, then I guess you could take the second question would be, what's the impact of the 2019 decision? And the effect of the 2019 decision could be that this has already been considered and decided, and therefore we're going to just follow the decision that was made in 2019. And you can make findings that it was the same parties that were involved, that it was the same use at the time, and therefore applying the rules of res judicata that you're going to follow the decision that was made back then that the use is not allowed. So really, it's the same determination. It's just a little bit shortcutted if you are going to defer to the 2019 decision. I think that there was some discussion about whether the use had changed since 2019. So it's really important to define what the use is first. And then you're free to either do the analysis directly or to defer to the 2019 if you think that applies to the same extent.
Well, it certainly seems that at least as of May 19th, 2023, the use was likely falls under the events-based rentals. I mean, I'm just taking that from the annual report filed. I mean, that seems like I don't know how else to classify it other than how they've classified it.
So, Attorney Hamer, you got 5 different people here with 5 different thought processes and trying to wrap their heads around what they've heard and some sort of nagging stuff with how to look at it. I'm going to advise our board to talk out loud, obviously, and try to work our way through this. If you hear us starting to go down rabbit trails, please chime right in and just say, hey, I'm not opposed to that. But we're work our way forward with this, and please feel free to provide guidance as necessary.
Sure, and at some point, I would hope to hear, it's up to you, but I would hope to hear a motion to find, as a matter of fact, that this is what the use is. If you get to the point where you think you can put together a motion that's going to describe what the use is, and everyone will agree to it, once you've voted on it, then you can move on to the next step.
So determining the use, I need to make sure here, is the determining of the use what we heard, come from what we heard here today, or do we then take that and compare, does that use sort of have to come out of the notice of violation, or is that use coming out of what came in the record today, and then we move towards the notice of violation?
So you're assessing all the evidence that's been presented to you, the testimony, the documents, that universe of information you get to analyze, and from that you can decide what the use is.
All right, and so that includes the notice of violation itself as well?
Yes, that's some evidence of what the use is. I think that you've had some testimony and some descriptions about what the use is that's more direct than the notice of violation. The notice of violation is evidence, but there's a lot of evidence you can consider.
Right, yep, gotcha.
Hey, David, this is Tom.
Yes, Tom.
I mean, if we're trying to figure out the primary use of the property, can we say that it's not technically short-term rental of lodging, and it's really rental of the property for private events?
Well, I think the primary, just to clarify, I think the primary use is a single-family dwelling. Is that the?
Well, it doesn't, right. I think you're right. The primary use is.
And they rented it once.
Right, but I think we're needing, if I'm hearing Attorney Hamer right, is we're trying to determine what was the use that sparked the violation, or the notice of violation.
And I would suggest it's not because they are renting it seasonally or weekly or monthly to visitors to live in the house. It's really to short-term throw a wedding or a party of any sort, and it's really the property is a private events rental. It's not a house rental.
Be curious, does Pete have any input?
Yeah, Pete, what's kind of going on with your thoughts on this?
Yeah, of course, as I'm listening to you guys, I'm struggling with a lot of the same things, but I'm inclined to agree that, the use of the property sounds to me more like it's for events and not to rent out the residential house. That's kind of my thought process as I listen to everybody that is speaking.
I really don't want to go backwards, but when we're being instructed to define the use, or are we talking about the primary? I mean, I think they live there. I don't like. I think the actual primary use of the house is a single family dwelling.
Yep.
And I think now we're talking about what was the use that occurred on that's relevant to the NOV, which is something else. Is that the right way to think about it? Or is that how you're thinking about it?
That's how I'm looking at it. Was there a use that goes against a permitted or conditional use of that property? And if it goes against conditional, did they have that conditional use? If they didn't have the conditional use, then it's still good property. At least that's at this point how I'm looking at it. So, Attorney Hamer, again, thank you for being patient with us. to Greg's point, which I think is a good one, there appears to be, at least for year 2024, basically a 360-day use of the property as a residential home only by living, the appellant's living there. And then there's an approximate 5-day period for which something else occurred. Do we need to worry about the 360 days and that sort of that permitted use that we're sort of leaning towards, and then the other 5 days which are potentially not permitted? Again, we're trying to make sure we're looking at this properly in fairness of the appellants.
Sure, and I certainly think that it's clear that the property is a mixed-use property. That one of the uses, which is not contested and not controverted, is the residential aspect of the property. The family lives there, and that's not why the notice of violation was issued. The notice of violation was issued for the other use. And so that's really what, I suppose in making your findings, it's fine to say that, there's one of the purposes of the property is residential. The other purpose of the property or the use of the property is such and such. And the appellant suggested that it's an accessory use. The town suggested that it's not. So that's what we're honing in on, but you're right, it's a multi-use property. It's with residential being part of it, and then the part in controversy is really what you need to focus on.
Thank you. So the nice thing is this notice of violation includes the ordinances that we need to review, at least immediate impact. So we have rural district. Oh, actually, we can't look at that because that's for rural. We gotta look at rural residential. That worked out well. Opened right up to it. Yeah, okay. Permitted uses. Okay. Rural residential district. Intent. Town of Raymond recognizes that certain areas of town will experience residential growth due to rapid population growth in the region. It is the intent of this section to allow these uses while maintaining the basic rural orientation of the community. Permitted uses. 1. A one-family dwelling to include manufactured homes, type 1 and type 2. I'm going to move forward in the assumption that we are all in agreement that that is a permitted use for this property, and that's how it's being used.
For the majority, that's the the primary use.
Primary,
and then there's the use in question. Right. Which
permitted uses, church, no. Schools, I would say no. Public buildings and facilities, that's no. Agriculture, excluding commercial poultry and piggery operations, no. Never thought I would ever say the word piggery. Number 6, use accessories and buildings. So there is a use.
Which one is this? I was looking at the 30-4.3. Is that not?
Yeah,
30-4.4.
It has to be 4-4 because what was provided was for rural, not rural residential.
Accessory use in buildings, number 5.
For 30-4.3.
30-4 permitted uses. Number 6 is accessory uses in buildings.
Okay, well, it's the same wording.
Well, that
I think
works.
it's just 5. It's just worded slightly different.
Okay.
So unless there's
As long as we're in line with this.
Yeah, fair.
Yeah.
And I think that's the appellant's central argument, is that their use falls under accessory use.
Right.
I mean, I think that I would be more or less comfortable with a motion to define the use in question as event space rentals with decorating, consultation, and vending coordinating, or vendor coordinating.
I would too, but I want to be fair to the appellants and make sure that, you know, we,
Well, that's still, I guess what I'm saying is that still could be an accessory use.
okay.
I'm not saying, I'm definitely not saying that that's not, I don't think they're, I'm not even sure if they would refute. I mean, this is.
Got it.
Just like May 19th, 2023, I mean.
Okay, I'm good with
That's
that.
all I would say. That's all I
I
would say.
certainly don't want to skip past this. in
Yeah,
terms of
sorry, I was just trying to
discussion. I
make
agree
it
with you.
these two, the question is these two things then, right? That was my thinking. I mean, let's discuss it, but that's sort of where I was leaning.
If you'd like to make the motion, I would love.
Yeah, I'd like to move to, I guess, classify the property's use as its primary use as a single-family dwelling, and with the use in question, per the filing with the Secretary of State, and an event space rentals with decorating, consultation, and vendor coordinating. That would be my motion, I think, unless Attorney Hamer wants to help me tune that a little bit.
I would like you to repeat it.
I said I'd like to classify the property's use, the primary use, single-family dwelling, and then the use in question as event space rentals with decorating, consultation, and vendor coordinating. As a finding of fact, I guess I would like to say. I'd like to say it in that way.
All right, and with events-based rentals with, I'm trying to write this down, that's all.
Yeah, I'll just read it. It's from the Secretary of State. It says event space rentals with decorating, consultation, and vendor coordinating.
Okay.
And this is Tom. Is that qualify then as a commercial enterprise?
I think the first thing you do is you make the finding of fact, and then that's your next question. What is the nature of, once you have the use, then you can take a look at the ordinance and see, is there a use where it would fit?
Yeah. So my motion is to, as a finding of fact, the property at the time in question was used as an event space rentals with decorating, consultation, and vendor coordinating. That would be my motion.
I would second that. Do we have any further board discussion before we vote on that?
Are we talking about this one event, or are we talking about future?
But we're talking about this one event, but I'm using their language of how they've described their operations, which I think, I'm actually not sure that they would disagree with that. But I'm just trying to narrow the scope of the problem down. And then I think, then I think there's a follow-up question, which is perhaps more difficult. At least that's.
I'm okay with that, I agree. Yeah.
So we'll go ahead. All those in favor of accepting Greg's motion, David Murch, yes.
Greg Dean, yes.
Fred Miller, yes.
B. Lockwood, yes.
Tom Hennessy, yes.
Okay. So we have agreement then that there was a use of the property as an event space rental with decorating, consultation, and vendor coordinating.
So from my perspective, the next question is whether the 2019 decision makes your decision easy or whether it does not, and then you can take a look at the ordinance directly and see if that use is allowed there. That's just a suggestion.
Should I make one comment?
No, you may not. Whew. So I have the conditional, I have the appeal, findings of fact and decision. Appeal is for conditional use. Todd Roma, Jessica Dobson, 141 Raymond Hill Road, map 13, lot 29, zone RR, which is the property we've been discussing. On May 24th, 2019, the ZBA held a public hearing on a conditional use permit in the rural residential zone. Mr. Roma and Ms. Dobson own the Roma Farm, which includes a farmhouse and barn built around the 1800s. I'll sort of skip some of this. They would like to hold a few seasonal events from July to the first week of October each year at the property as additional income. Questions were asked of the appellants and Ms. Plummer about various concerns about noise, portable water, parking, number of events, and size. Board discussion took place following close of the public hearing. Please see the video, see video record. And let me find the original appeal. What exactly was the appeal? Totally lost track of all my papers. Anybody have the original appeal in front of them? No. The actual application itself?
Yeah, right here.
So, in the application itself, conditional use permit for a barn venue for use in RR zone. Barn venue. And we have the letter that was written that I quoted portions of. Which talks about how they would conduct the business, indicating that they were looking to move forward with rentals.
Yeah, I mean, again, I mean, I don't know the Latin words that are thrown around as well as, at all, but this to me seems like they're arguing a different point altogether. I mean, what was found in 2019, I think there's obviously some facts that are relevant in terms of continuity of the use and whatnot, but I mean, they were advocating for conditional use that was not granted, and it sounds like here they're appealing a violation based off of the fact that their uses falls under a permitted use. And then and my understanding of the central argument again is that permitted use is an accessory use. I think that was the core argument.
Yeah, and so if I was hearing Attorney Hamer right, he was tasking us with is a potential that the ZBA in 2019 was faced with a similar issue as we're being faced with now.
Well, I mean, it was
I don't know as in the original appeal that it was presented as an accessory use.
Right.
It was presented as a rental of the property for use as an event venue.
Can I just ask a question?
Yeah.
What is the ordinances now for the 2024 violation?
I think the ordinances are extremely similar, except perhaps solar farm, or I don't know if that's still there or not.
Yeah, I see what you're saying. Because the finding is suitable conditional or permitted use.
And the way it was used then, it was never brought to the ZBA that accessory use was something for the ZBA. If it was a permitted use, there would have been no need to go to the ZBA.
Yeah, I think they just thought it'd be better business-wise to have a conditional use permit.
Right.
If they had not come up, they would need to.
Yeah,
that wouldn't even have been in the record.
It just seems like I don't know. Hinging too much on that seems like they're just going to be a victim of trying to do the right thing. I think that, like, their argument now is their use is an accessory use.
Right, so what's our?
I don't know. It's a good point. I don't know. I'm just trying to make sense of it.
So I guess we have to, let's hold on the 2019 ZBA discussion, recognize there may be points perhaps that we need to glean from it, but then look at it too from the accessory use, from our own perspective right now.
I think they would fall under, because their violation is for 2024. So we should be using the 2024's regulations, right?
Yeah, that's a good point. It could be something that's changed in those 5 years. What do you have for accessory uses?
Yeah, I gotta find the definition.
Much easier when you get a computer in front of you.
I was just thinking of that, Fred. Somebody else wants to search these, or am I the only one who brought their book?
I brought mine, but mine's just not as big.
Wait a minute here.
You wouldn't happen to have any guidance on where to look, would you?
It's 312.1.
Thank you.
Is it probably in your submission?
In the letters.
Yeah.
I knew it was.
But
You
what
had
two,
these
actually?
312 too. Aha. Still the only one. Yeah. All right. We're looking at this from accessory structure or accessory use? Both.
Accessory use, I think, to begin with.
So an accessory use is a use which is incidental and subordinate to the principal use. Accessory uses, when aggregated, shall not subordinate the principal use of the lot. What I find interesting is the accessory uses, when aggregated, shall not subordinate the principal use of the lot. I mean, if you look in terms of what was discussed with the weddings, it's the barn, property, and even an associated lot. So that certainly bigger than the principal use of the lot. I mean, the whole, even the house is used for the wedding. So the whole, yeah, accessory uses when aggregated shall not subordinate the principal use of the lot. Principal use of the lot is as a single family residential. Use which is incidental and subordinate to the principal use. Incidental and subordinate.
Well, I mean, one of the lots in the NOV actually isn't a primary residence, so maybe we were a little too broad with our classification. Because one's just vacant land.
Well, lot 30 is not even part of the NOV.
Good point.
So we're looking only at
So
lot
we just
29.
ignore that.
Yeah,
Yep, easy.
but, yeah, but I guess, I agree we ignore it, but the use does overflow into another lot. That's the only thing as I think through about when it aggregates, but I know you can't aggregate to 30.
Yeah.
Lot 30, but it's still, it's overflowing into 30, which means is the use of the property more so than just,
I'm looking at it, lot 29.
Mhm.
And I think that's like aggregate, like if you were to aggregate all the accessory uses on lot 29. I don't think we can consider other lots.
oh, no, I agree with you.
Oh, okay, okay,
Yeah, no
okay.
question.
All right,
Yeah.
it's just-
No question about that.
All right.
My only, again, it's just a thought process that I go through is this, what's happening on lot 29 is so big that it has to go into lot 30.
Oh, so it speaks to the
size
what incidental nature of the use.
Yeah.
Of-
Again, I agree 100%. We
29.
can't focus on lot 30.
We want to go to the Zoom folks at all? You guys have anything? We're just chatting here about the accessory use or definition. Or Brad?
I think the code enforcement attorney there used the word, it's the business of renting it as a private event place has subsumed, I think was the word he used, the primary use of the residence. And the fact that it actually, has lapsed over into the second property for parking. So I don't know if that makes a big difference, but I think the other part is that, if the primary use is residential, the event business is a business and it's, commercial, which I don't know that that's an allowed use in, the RR zone.
Can we have our attorney give any input on what he just said?
If you'd like to ask, Fred, I don't mind.
Well, I think. Oh, sorry. You want to ask?
No. Well, I don't even remember.
You can have a home occupation, but this doesn't qualify as a home occupation.
Yeah, but you're allowed to rent your property and make money. I mean, that would be considered, by your definition, just making money. I don't believe, I don't think it's as cut and dry as making money makes it.
Right. I agree with Greg. I mean, we have information that leads to short-term rentals are.
Or long-term rentals.
Or long-term,
I mean,
yeah.
just yeah.
I don't think the rental of the property for, well, we already defined a rental for the
Yeah,
property.
it's the event part of it, I think, is
Yeah.
what we're gonna have to get down to figuring out, but
Yep.
the rental part of it, I think it's like,
If I could make a suggestion.
Please.
The ordinance is fairly sparse with this definition of accessory use, but the applicant in their argument letter on page 2 under discussion point 1 did provide some excerpts from law court opinions that might help evaluate accessory use if that's of any help.
So much paper.
is this Bovin versus Sanford?
Yes.
And Shapley versus Schickel?
Yes. That gives you some factors that you can consider, which might be helpful.
Kind of read some of this out loud. Means law court has recognized that an accessory use is lawful if it is dependent on a principal use, has a reasonable relationship with the primary use, and is customarily associated with it. see Boven v. Sanford. The law court has explained determining factors of whether a use is accessory. These factors include, but are not limited to, the size of the land involved, the nature of the primary use, and the economic structure of the area. Town's ordinance does not list wedding venue, private event space, function hall, or other similar uses as a permitted or conditional use in any zoning district. Such uses are not considered by the ordinance whatsoever. In fact, there are not any permitted or conditional uses that even remotely relate to private event venues. Either the ordinance creates a blanket prohibition of such uses across the town by explicitly omitting them as permitted and conditional uses, or they are allowed as accessory uses for certain properties. Applying CEO Hansen interpretation would mean that no property in the town of Raymond could host private events regardless of zoning district. Such an interpretation would lead to an absurd result that is clearly contrary to the town's intent. So,
I don't know.
So I interrupted your train of thought.
I was gonna make a recommendation on that, in a very narrow manner, would it be, like, when I see like referencing case law, it just seems out of my, expertise. I mean, we're not particularly reading the case law, but it's like,
I agree.
okay, like maybe it would be helpful in a very narrow manner to ask the appellant's counsel to recap that and give the town an opportunity to rebut that. I don't know. I'm just throwing that out there as an option.
Yeah, our own attorney.
Okay.
We need to.
Yeah, we can do that.
Attorney Hamer, I'll speak for Greg, but Greg can interject in a minute. Are you willing, or is it acceptable for you to, if you're familiar with this case of Boven v. Sanford as well as Shapley v. Sheichels, to provide any comments to us with applicability?
I've read them, but it's been a long time. I can pull them up for you. I'm not sure that the fact patterns are going to necessarily be helpful. I think that this is a very fact-specific analysis. Each case is going to be different, and that's why the law court has tried to provide some guidelines. When it comes right down to it, generally the idea of an accessory use is something that is done on the side. It's not the primary purpose of the property. It's something that's subordinate to the primary use, which is the language that's used. Things that the law court points to, whether there's a reasonable relationship with the primary use. Is this something that typically you'd expect to see in a residential household being done? A lot of accessory uses are things like gardens or things that you normally see in a house that's not necessarily residential in nature. Those are accessory. In terms of your very limited home occupations, those are considered accessory because, it's not unusual across the United States for someone to have, say, a hair salon in the basement or something like that. And there are narrowly confined regulations to deal with home occupations, but that's an example of something that would be accessory. Really, it's a question of really capacity and size of the uses that are compared. If you've got a use and you see that the property is really primarily being used for a commercial enterprise, then it's probably not accessory to the residential component. If you see that the use that's being done on the property is not reasonably related to the primary use, then it's probably not accessory. And what was the other one here? If it's not customarily associated with the use, then it's not going to be an accessory use. So at some point, It's just going to be a matter of you folks applying the facts and saying, do you think it's accessory based on these general guidelines? And it's, at some point, it's just a matter of you got to make a call. How's that for a non-answer?
Boy, I mean, that is. Yeah, the reason why I hesitate to go based off from the language provided by one side, right? And so, like, we've got a synthesized version of the case law from the appellant, and I just thought, you know,
Yes, it was provided by the appellant, but it was also cited by the town.
yeah, okay, fair. Where is the town citation of those? Was it in your oral argument?
Yes, it was in the oral argument. Or no, it wasn't the town. It was the comments of the public person who was opposing the appeal.
Okay, the public. It was the public, the counsel for the public. Got it.
Yes,
Or from a member of the public.
attorney's name, but I can find it.
Yeah.
Does anybody? I'd love to get the other side of that. I don't have notes on it, but
Unfortunately, no. I do have, in the original appeal, they do indicate this, which could be helpful. Our barn was renovated in 2007. During the renovation, the barn had an all-new metal roof installed, electricity, lighting, and a recent addition put on the side for extra storage. The barn foundation was also re-supported during the renovation. We have hosted yearly family parties of 130-plus people with no problem. And part that I'm looking at, the barn even holds our cars, tractors, and storage in the winter.
I think a barn is definitely an accessory
Yeah.
use. It's just the question is like, is there events in a barn? Like, and
Right.
then I think there's is the scale of the event in the barn an accessory use?
Right.
That's-
Yeah, I just read that to show that they
Yeah.
are using it for non-event purposes as
Yeah.
well, which I would agree
I mean, if I had a
would be
barn,
considered, yeah.
I would have an event, yeah. I just don't know if it would be the scale, but it certainly seems like having an event in a barn, like an event in a barn seems like squarely in the definition of a barn.
But
But it's expanded beyond that to, you know, a large tent and porta potties
Yeah,
and
yeah. The scale,
You
I think,
know.
is a different question. I'm just saying
Yeah.
the event.
when you're hosting 150 people or whatever the number was.
And I think the other piece that we got to focus on is that it was done for rental purposes. It's not just, and it wasn't just done as, I'm going to do this for free for family and friends. This was rented for purposes of income for this.
Yeah. Does that actually matter? If this goes back to that circular definition, right? Like if I own property and I'm allowed to rent it, if I rent it and it's used in a permitted manner, that's a big leap. I'm not saying that's what we're dealing with here, but I'm just saying the rental part of it seems not to be the issue. Or am I mistaken? As long as it's a permitted use, like. Because if it's an accessory use, you can rent it. For a permitted, you can rent it no matter what, but the use of it would be permitted. That's what I'm trying to say.
Right, but it's being, well, to be clear, the property itself is being used for event space rentals with decorating, consultation and vendor coordinating.
Yeah, fair.
So how does that fit? I don't disagree with what you're saying.
Yeah, I'm not concluding anything. I'm just
Yeah,
trying to talk
I know,
through it.
talk
Like,
through.
there's a, you know.
That seems very circular.
The problem is that we're basing on 2024. That's where the notice of violation is. And there's only one event in that. Versus they're using it to put their tractor in or whatever in. You know, and I don't know exactly, you know, if I look at thinking about on the side of the code enforcement, they're looking at it as that, using it as an event business with revenue. That's the violation, I think, that the code enforcement is trying to say that that's where that's coming in at. We just gotta figure out where are we at as far as how that is that a violation or is that not a violation because it's accessory, or is it
right?
Is it a non-residential and more of a business? And, you know, the information we have from the past is that it seems to have been used more as, well, we don't know how much, but it sounds like they said that they've had up to 130 in there. So obviously it's been used for, or it sounds like it was used as some kind of sort of commercial. Or
They have said, yes, that they have rented the property in conjunction with private events beyond just the one, but they've also indicated that they've just had, you know, family and friends.
Right.
You know.
Which we heard in the testimony saying that they've been there for a 75th birthday and.
Right.
And
so there's both uses, both as basically personal use and then for profit use.
I guess I'm just.
Hey, not to throw an extra twist in here, but under permitted uses, this might set a kind of a tone. Number 7, bed and breakfast inns not to exceed 5 rental rooms and not to serve alcohol. There's even limits on bed and breakfast operations. And we know from their actual statements they're serving alcohol at this place.
Well, right, but that's just another permitted use that they're not claiming they're a bed and breakfast. I don't think.
Yeah, no, I'm just showing that rural thing has some limitations on it. That trying to, you know, keep things small and rural, I guess.
I don't know. I mean, I guess like maybe it'd be helpful for me to get clarity on whether or not we care about the rental aspect of it. I feel like that's sort of muddying the conversation. Like,
to me, that seems the key piece to it all.
Why is that?
Because if they want to use their property and have, you know, a wedding a weekend and do it for free, that's fine. That's their property to use as they would want. But when you add the aspect of renting the property for use of having, you know, weddings, seasonal weddings or seasonal events from, say, July through October, you know, that's the piece to it, is the rental piece is the key piece to it. It's for profit. And that sort of comes out in the decision, you know, from the 2019 ZBA.
Right, but you're allowed to rent your property. Like, especially if it's clearly in one of these uses. Right, and I think all we're deliberating on is whether or not what happened is in one of these. The renting, I don't know, like, in fact, some of these are just renting, like it's actually in the use. Like, I think you could rent your property to, somebody who wanted to, you know, do one of these uses. You could do a long-term rental to a church, for instance, and I don't think you'd be in violation because you rented it. That's sort of my thinking.
I'm not sure I follow it, though. When, elaborate on the church part.
Well, that's a permitted use.
Yep.
Yeah, so the fact that you're renting it doesn't really, like, matter.
For what it's worth, if I may interrupt, you did make a finding of fact as to what the use is.
Yeah.
So you don't necessarily have to dissect it and decide what the single component is. It's not a single component, it's the use overall. You've got a event-based rentals with decorating, consultation, and vendor coordinating. That's your use that you found exists out there.
Right.
So you've got that part. So you don't need to necessarily define the edges of how narrow it could be.
Okay. Man, it would have been sure would have been easy if they'd put event-based rentals on permitted use. That's all I want to say.
There's no, as I said, there's always, somebody could go in and try and change the ordinance. Might take a little time.
I think that's the. I mean, ultimately, it's either it fits into one of these or it doesn't. I don't know. To me,
sorry. Can we figure out that it doesn't fit home occupations?
But I think we have to do it based on, I agree with what Attorney Hamer is saying, is I think we're trying to decide the accessory uses.
like, is event-based rentals with decorating, consultation, and vendor coordinating
Yep.
an accessory use? I don't know. I remember.
I think if it was potentially limited to the structure of the barn, it might be easier, but.
True. I definitely agree with that. The scale sort of matters. I don't, like, there's nothing in the definition of it except it's just the incidental nature. It does sort of, but.
I mean, it encompasses the entire property. Barn, land, and farmhouse.
Well, it's, how many acres is the lot?
Oh.
So, I don't, if they had Woodstock there, that might be the entire property, but.
Well, no, I mean, my point, I'm not going to say every square foot of it's occupied, but my point is that the barn, the wedding is not limited to the barn.
To the accessory building.
It includes the barn, includes the outside use of the property for the porta potties and the tent, most importantly the tent, and it also includes the use of the farmhouse itself as well. So the entire property is being used for this purpose.
Yeah, and that would not be allowed as a home occupation. So.
No, I don't think we're looking at it as home occupation.
I think it's a fair point, David.
Just trying to qualify that it doesn't meet that one. So.
I think if it was not the scale that it would be more easily.
Yeah, I agree.
As
If
an
it was in a barn, if it's solely in the barn.
Well, the barn and maybe, a little bit,
Yeah.
but like, it does seem pretty, I didn't. What dates are these? I want to make sure I'm looking at the right towns exhibits.
Yeah, 2019.
Because we're gonna put
not 2019, but
we got to put in our write-up.
Yeah.
Probably should have said it on the first motion.
Yeah, it's 2020, 829 and 830 is what was indicated in the NOV. What's that, David?
I'm just trying to find the photos from the event. The event.
I don't know if we got actual event photos.
No, not for the, I don't think.
I got that one.
But that's from 2019.
Oh, no,
Right,
this
right.
is not, this is.
No, you're right.
Yeah, these
You're
are-
right. Okay, this is
yeah.
Jason's photo.
But that's not, is that the event?
No, I
Oh,
don't,
that's just a picture showing the, yeah.
but I think, I don't know if Greg was looking for
Yeah,
perspective
yeah,
at the
yeah.
time.
That's exactly what I was looking for. Okay. Where's my copy of those? Did you steal those?
I did not.
Harry stole my water.
Got some backwash if you want. Have anything you want to add, Pete? Oh, Greg looks for stuff.
Not specifically, David.
Okay. Anything unspecifically?
No.
Okay.
Okay. All right. I found it. Yeah, okay. That doesn't really matter.
I was kind of do like a straw poll. I'll let you read. Fred, are you leaning more towards this following the defined use that we accepted? Do you find that fitting under accessory use or no? Are you leaning more towards it falling under there or no? Trying to decide if I need to make a motion.
I mean, it's so hard because one part of me says it is, but the part of the scale of it is what's offsetting it some. So, I mean, you know, I don't know.
Yeah. Pete, Tom, I'm just trying to do like a little straw poll. Are you leaning more towards this being the established use that we accepted? Are you finding that to fall more under accessory use or not? We're not voting on this. I'm just trying to get where are we leading towards this?
I'll speak first. I'm leaning towards the not side.
Okay. Pete?
Yeah, I'm leaning towards the not side as well, I think, because of the size and the scale.
Yeah, and I'm leaning more towards the not size as well because of scale. And there is already, I do see an established use of the barn for barn stuff, and we know that they do functions, but this whole, yeah.
Yeah, I mean, you've got, it looks what appears to be, you know, trucks coming and setting up equipment, event parking. This is a pretty big event.
Yeah.
Well, I think the whole Wiener, and our notice of violation is on this one day or this one event.
Right.
I think that's what we have to concentrate on.
Yeah, I agree.
That part of it.
Yeah. It was one day this past year, but they themselves said they've had multiple ones over the past, decade or whatever.
I mean, I think that if anything, I would really like to emphasize that it's the incidental nature of it that is the disqualifying factor for me.
Yeah.
I think that if this was a incidental event, kind of commensurate with owning a barn like that, then I think it would be a lot easier to get there.
So Attorney Hamer, we're all sort of leaning towards this to be not falling under an accessory use. How can you, what's our next steps here?
Well, I think at this point, if you are ready to make a motion, then you should make the motion, and then before you vote, explain the basis for your decision. And once you have all decided whether it qualifies as an accessory use or not, then you can take a final vote on whether you're affirming or modifying or striking the NOV.
Okay, so I want to frame this as a motion. We've done good so far, Greg.
Not particularly.
All right, let me. Motion.
I mean, did we? Yeah. Go ahead. Sorry.
All right. Just want to make sure I'm serving everybody here properly. Attorney Hamer, I'm making the motion. If it potentially gets a second, then we'll take an opportunity to discuss it further. During that discussion, we'll elaborate further on why we feel it does not fall under accessory use, correct? And if there's opposing views, those will be discussed at the same time.
Good plan.
Okay, thank you. I will make a motion that the use of the property as event space rentals with decorating and consultation and vendor coordinating does not fall under the permitted use in the rural residential district as an accessory use. Do I have a second?
Do you want to add to why, or is that?
Well, I think that was coming out.
After the fact.
If I get a second, then we discuss it.
I'll second it.
Okay. So, reasons we've discussed is for scope, right?
It's the size
Yeah.
for me. If it could be incidental, I think it's permitted. I think it could be an accessory use of a barn, for sure.
Totally lost my notes. Use is incidental and subordinate to the principal use. Yeah, it's just, for me, it's, again, it's beyond the incidental and subordinate principal use.
It does not appear to be incidental to the.
Right.
Yeah.
Fred or Pete or Tom, do you want to have further input into this, either for what we're talking about or against what we're talking about?
The thing I have to say is, I still have a hard time driving this in my head, is because if they hadn't have come to us, then this wouldn't even be talked about, because they had started this deal. But unfortunately, that we have an ordinance that says that, something of that scale is not fall under the ordinance for their area of the route, RR.
Well, I don't think we're. Sorry. Go ahead.
Go ahead, no.
No, I was just saying, I don't think that, just to clarify my position, is I'm not hinging this on the previous findings. I'm saying that evaluating it fresh as an accessory use, it does not appear to be incidental to the primary use of the property.
And that's what that we're falling under the 2024 ordinances, right?
The
We are
current
looking at
Right,
that.
Yeah.
that's what we're talking, that's one we just read it a little while ago.
Yeah.
So that's why I'm saying, that's why I think that we're coming closer to where we're going than what my first thought was, that if they hadn't come to somebody and said something about it, then, you know, it may not have ever been a situation. But now, it's a situation because of where we're at right now.
Did
And
they
it's
amend-
because we're going on the basis of what the rules and laws are for 2024.
Correct.
We're not talking about what happened in 2019.
Correct.
So the code enforcement is using the 2024 rules and regulations for the novena, the notice of violation.
Correct.
But the event occurred in 2024.
But we're using we're using the ordinance for that to back up his notice of violation. And if we follow the rules, that what says in that, then the scope of it is, it's not used just as an accessory, because they're using tents outside, they're using porta potties, they've got, again, we're not combining it just to the barn.
Correct.
So I think that I think we finally come to a decision.
Okay.
That we have to follow a rule of the ordinance of 2024. Is that correct?
Correct. Yeah, everything at this point, because we looked at 2019 appeal, and we decided to set that aside for now because we wanted to focus on the incidental use, which was not at all part of the 2019. They had a different, they were looking for a conditional use.
Right.
We're looking at this as whether or not as a conditional use, but as a permitted use. Does it actually fall under one of the permitted uses?
Right. So the violation that we're looking at is only to do with the 2024 notice of violation. And we're using just that rule for our decision.
Correct.
Hey, this is Tom. The other thing, I guess, if we want more rationale, is, in paragraph A, it says the town of Raymond has historically been a rural town. It is the intent of this section to protect and preserve appropriate areas of town from urban sprawl by designating uses and standards that are appropriate to a rural character. So, big tents, porta potties, hundreds of cars and people. Maybe there's another reason in there that doesn't fit rural character.
Yeah. I hear what you're saying. I sort of think an event in a barn is pretty rural. It's just I think it's the
scope of it and the fact that it's, coming with a price tag.
Yeah, I think that price tags is not really something that we've already, well, I don't know, at least to me, it doesn't seem like that's something we need to deliberate on whether or not you can rent your property.
Nope, not saying that. Just saying the scope of this is because it's gotten larger and larger probably over the years. From, a small event in birthday parties in a barn to, major events with music and alcohol and all the rest of it.
Yeah, I hear what you're saying, but the evidence that I'm basing my decision on is just the scale from the evidence provided from the town. Which appears to be trucks delivering tables and a tent outside and, event parking, parking lot that spills over into a second lot. I think like an event in a barn, even a rented barn, would still be fine as an accessory use of a rented property. But I think the magnitude of this is the issue where I kind of land. I don't know.
So hard.
And I would like to also agree, I mean, I think it's the scale. I agree, Greg, that if it was limited to the barn, that could, basically fit. But now that there's a tent, and then I think there's even potential for it to grow even bigger with the additional property.
All right, we had the motion, correct? We have the second, we've had the discussion. We'll go ahead and vote. All those in favor of the motion indicating that this event did not fit under accessory use or this purpose. All those in favor, David Murch, yes.
Greg Dean, yes.
Fred Miller, yes.
Pete Lockwood, yes.
Tom Hennessy, yes.
So Attorney Hamer, we've come to the conclusion that the use that we established was not valid as an accessory use.
And that was what the appellant argued. So given that fact, do you find that the appeal should be upheld or it should be denied?
Oh, it's gonna have to be denied. Well, we'll have to make a motion to deny. Is it as simple as making a motion to deny the appeal? I'll make a motion to deny the appeal. Do I have a second?
Are you waiting for a second?
I'm waiting for a second, Tom.
I'll go second.
Okay. Do we have any discussion?
Other than it's yeah, no.
Yeah. I'm right, I think in the same spot as you.
Yep.
Yeah. Okay, all those in favor of denying the appeal, David Murch.
Greg Dean, yes.
Pete Lockwood, yes.
Tom Hennessy, yes.
Fred Miller, yes.
Okay, unanimous. Attorney Hamer, anything further on our end?
So at this point, now that you've taken a vote, I will put together draft findings and conclusions for you. And at your next meeting, you'll have to review them, change them as necessary, and then approve them so that they can be issued to the parties.
Okay, I believe we have a 16-day window for that.
All right, well then, within a meeting set within that time frame.
Yeah.
Would be good to know.
Okay, and we can perhaps discuss offline with Sandy, but we've never officially had a meeting to discuss. We can certainly schedule one if you think is wise.
I usually recommend that there be a meeting so that you can review the findings, and if you want changes, then you can instruct me how to change it. But
Okay.
absent a meeting, you can't really act, so that's really the proper way to go.
Okay, we'll work through that after this, figuring out a date. We'll work with Sandy to establish that date. Code enforcement, what do the appellants, the appellants have a notice of violation. I just want them to be clear what their follow through is with regards to the notice of violation itself. I think in the NOV itself, it indicates contacting the code enforcement office. Is that still the appropriate moving forward?
So we'll be in touch with the appellant after we've had the meeting on the findings of fact.
Okay.
And we'll give them direction at that.
So, Mr. Skolnick and Mr. Roma, we will have a meeting with regards to the finding of fact. Ensure that's correct. Sign it. Code enforcement officer will then be in touch with you regarding the NOV.
Thank you.
Okay, thank you.
Greg, you gotta end the meeting.
Oh, you got to end the meeting.
Well, we still got, next on our agenda is code enforcement office communications.
Thank you.
Yeah, because they set it up for that. Yeah, we'll talk to you, yeah.
Definitely do that.
Right.
I would turn
We
that.
want to limit that. Yep. Touch base with Phil on that when you get back. And we can have communication on that. Typically how we solve them.
Do you need me to continue, or?
Yeah, I'm just waiting for code enforcement. I got to get their attention. Oh, I'm sorry, that was you, Attorney Hamer. So I think we're good. I will work with Sandy to establish when our next meeting is to get that discussed and signed. It will have to be within the next week.
You'll have to be set up pretty quickly, yes.
Yeah, so.
No, I can't give you dates, David, until I'm in the office tomorrow morning and can look at the calendar of events
Yeah.
to see what dates will be open for having the broadcast studio.
So Attorney Hamer, obviously there were 5 of us here. 2 are not here currently in Raymond. I'm not sure when Tom gets back or Pete gets back. In terms of the meeting itself and getting things signed,
Said you could have it in the
what attendance are you looking at so that this is all valid?
code.
I will send the draft to Sandy, and she can provide it to the board. And then if they want to sign it individually and just send in the signature page, that's fine.
Okay.
Just scan it and then send it, that should work.
So Sandy, I'll let you work with Attorney Hamer and then you give us the correct next forward steps. Does that sound reasonable?
Sure.
Thank you. Thank you, Attorney Hamer. I appreciate your time.
Thanks for your time.
Thank you.
Thank you. Difficult one to process.
Yeah, I think we could.
Good night.
Good night.
Good night, John. Thank you.
Yeah, I would.
So,
Yeah, yeah.
so Chris, you got any code enforcement office communications?
Nothing
Jason?
coming down the pipeline, to my knowledge, at this point. Working on ordinance updates and no appeals headed our way that I know of.
Okay.
So,
No, nothing came in for next month, so we'll get this extra meeting scheduled and cancel the one for the 25th.
Is this one, Sandy, that we can potentially do as just strictly virtual? Or does it need to be done here at the broadcast studio?
It has to be recorded, but we've done that. I'll have to talk to Bill about that.
Okay.
But I think that they've recorded them before when we were only doing Zoom.
Yeah, I know that they did. I just want to make sure we
So
can.
it's just a matter of making sure we can get it recorded.
Yeah. Okay, I'm good with that. I'm just trying to figure out a way to make this work for everybody.
Right.
And if we can do it virtually, maybe that makes things easier for everyone. So.
Do we need to vote to keep the meeting going? It's past midnight.
Oh, yeah, well, right, so.
The only thing you gotta do now, guys, is make one final motion and let's get
This will
done.
be by far the easiest one.
Do I have an motion to adjourn?
Motion to it, yeah, so move.
And do I have a second?
I'll second it.
Thank you. No need for discussion. All those in favor, David Murch, yes.
Greg Dean?
Yes.
Yes.
Peter Lockwood,
So I'm gonna say yes.
Thank you, gentlemen, as always.
Thanks, guys.
Good night.
I'll
Thank you,
touch
Sandy.
with
Thank
you.
you.
Thanks, Andy.
Thanks.